Good afternoon, honorable members, the staff of Parliament, staff of committee, media, Office of the Chief State Law Advisor, the Parliamentary Legal Unit, PMG, and everybody on the platform. Today we're dealing with considering the submissions and the responses of department, and also vote on the clause by clause of the two bills. But what we're going to start with, honorable members, is that you remember in one of the meetings, there was a submission by CourtLink. It was more of a complaint to the Department of Employment and Labor, particularly the Compensation Fund. We wanted the advice from both the legal, Parliamentary Legal Unit and the procedural unit, but unfortunately both of them were not available at the time. I committed myself to make a follow-up on the matter for purposes of legal advice on how we should approach the matter. We managed to discuss the matter with the legal advice. We had a management meeting yesterday afternoon with the legal advice and also with the procedural advice. So I'm going to first check the attendance and if there are any apologies, and then after that we go straight to the issue of the legal advice on this matter, but also then consider the compensation or the COID amendment bill. But with the COID amendment bill, okay, let me come back after we receive whether there are any apologies, or first with the attendance.
Okay. Thank you, Chairperson. In terms of attendance, in attendance today, we've got Honorable Mashori, Honorable Dango, Honorable Moimang, Honorable Mamarahane, Honorable Duduvu, Honorable Boshoff, Honorable Bratasif, and Honorable Apleni. We also have standing apologies from Honorable Landsman and Honorable Matavula, and also from my co-committee secretary, Ms. Grace Denizulu. And in terms of the officials present today, we've got the procedural officer from the NCOP, Mr. Mara Ali. We've got the parliamentary legal advisors, Advocate Isaac and Advocate Mjenxane. I'm sorry if I'm mispronouncing your name. We've also got the state with apologies. And then we've also got the state law advisors present, Advocate Williams. And then we've got departmental officials also present, and just admitting on the platform now is also our researcher chair.
And also Suraya from the State Law Advice Office of the Chief State Law Advisor. Yeah, no, thanks very much. Can I then hand over to Mr. Mjenxane to take us through the
recording advice in progress?
So what we'll do then after that, we will then deal with the COID amendment bill. Yeah, after as soon as, because he is also part of the Joint Standing Committee on Intelligence. He has to be excused after that to attend to the meeting of the Joint Standing Committee on Intelligence. So that's why I suggested that we start with the legal advice and also deal with clause by clause on the COID amendment bill. But even on the COID, I wanted to suggest honorable members that in fact on both bills we focus first with those areas where stakeholders made submission, those sections. And then when we then deal with the whole bill in terms of, because there are amendments in other areas of the two bills, but there were no submission from the public with regard to some or other areas of the bill. So that's why I suggest that first let's deal with those areas where there are submission from the stakeholders, from the public. And then after that, then we deal with the whole bill in terms of voting clause by clause. So with this one, we will first deal with the legal advice. And then after that, then we deal with the specific clause that stakeholders made submission on. And then we go back to clause 1 of the bill, and we're done with it. We do the same with the with the employment equity, deal with those sections where stakeholders had submissions on. We finish with that. We then deal with the whole bill from clause 1 to the last clause. Agreed?
Agreed, Chair.
Thank you so much. Thank you so much, sir. Can we then welcome Mr. Mjenxane to take us through the legal advice? Just to remind, or maybe let me leave it to him also to remind the committee what the issues. Yeah. Over to you, Mr. Mjenxane.
Can you hear me? Can you hear me, Chair? Hello?
I think we can
Sorry, I'm muted myself now. We can hear you. Let me just explain. There's a chat, just to clarify the chat. What we're going to do now, the first thing is to listen to to hear from Mr. Mjenxane on the legal advice. Remember, Court Link made a submission complaining about the notice that was issued by the Compensation Commission. So he's going to give us an advice on that. And then secondly, we're going to deal with the COID amendment bill. I'm suggesting that we start with those areas where the stakeholders made submission, those particular sections. And then what we're going to do, we're going to go back to the bill itself, and clause by clause, we vote on clause by clause on that bill. And then after we finish with that bill, we go to employment equity. We deal with those areas that I don't want to say those areas that were contested. I rather say those areas where parties made submission. Parties like BUSA, COSATU, and other stakeholders. Those sections that they had a submission on, and then we deal with the whole bill, because the whole bill had some other amendments that I would say stakeholders were happy with or did not make submission on. So we vote on those. And then next week, after we're done with the bill, next week we will then consider a report, and then we will consider the report next week, whether we agree with the report or we don't agree with the report next week. So I just want to clarify, we're not going, for today, we're considering the bill clause by clause. Next week, we consider the committee report on the two bills, but we will have two reports, one for the employment equity and another one for the COID amendment bill. Thank you so much. Over to you, Mr. Mjenxane.
Thank you, Chair. Good afternoon to you and to honorable members. Chairperson, my submission to the committee this afternoon is actually quite short based on the advice that I have provided. I would just at this point love to confirm with you, Chair, if the members have been supplied with copies of the advice that we provided in order for us to decide whether we must flight it on the screen here, Chair, or if we should just continue to present from the opinion as members have been furnished with copies of the opinion.
I suggest that maybe we should flight it on the screen.
Okay, thank you, Chairperson. I'll ask my colleague Madia to just put it on the screen for members' ease of reference. Thank you, Chair. Thank you, Madia. And Chairperson, as can be seen from the screen, the opinion is quite a short opinion of about 4 pages. And in the opinion, Chair, we state briefly what the issue is, and we cite briefly what the law says about the issue, and then we provide a very short piece of advice to the committee on what
Mr. Mjenxane?
Yes, Chair, can you hear me?
We hear you, but then your voice becomes softer and we keep on losing you. I don't know if you...
Okay, am I more audible?
Yeah, audible now, but
okay.
as you continue to speak, your voice gets softer and we tend to lose you. So if maybe I don't know whether to stand still or I don't know, but there's some problems. We can hear you when you start, but we will lose you in the process.
No, that is fine, Chair. I'll try to speak as audibly as possible.
Thank you so much.
And my apologies, this technology is failing me. My laptop is a bit aged. No, thank you, Chair. Chair, I will proceed and present the opinion. It's a very short one, Chair, of about 4 pages, in which, Chair, we state what the issue is on which we have been asked to advise. We state what the law says about that issue and offer a brief advice to the committee on how it should further help the matter. Yeah. So just by way of background, Chairperson, this matter comes from the submissions to the committee, which have come through the public participation process on the COID bill, which the committee is amending, Chairperson, and looking into. It comes from the stakeholders. It initially was just one stakeholder, but later on has emanated, Chair, that there is more than one stakeholder which has an issue with this matter. And the issue really, Chairperson, relates to the notices which have been published by the Compensation Commissioner. Notices that have been published by the Compensation Commissioner as late as last year, around September, it must be, Chair, where the Compensation Commissioner exercised the power which is granted in Section 6, capital A, B of the Act, being COIDA, and published those notices, Chairperson, which seem to have aggrieved some of the stakeholders who have approached the committee with those grievances. Chair, we have looked into the law to try and scrutinize from a legal perspective whether there is any, from our perspective, legal credence into the complaints which are before the committee now, and what it is that the committee could do to try and assist the stakeholders with their plight. And Chair, from our analysis of the legislation in COIDA, a national legislation, an act of parliament, which was passed as far back, as in 1997, a piece of legislation. That act, Chair, provides directly in Section 6A, capital AD of COIDA, the power for the commissioner to publish notices. And if I could read it first for ease of reference, it says the commissioner shall, by notice in the Gazette, prescribe the rules referred to in Section 56(3)(c), as well as the forms to be used and the particulars to be furnished in connection with the notice of occupation injuries and diseases, claims for compensation or any other form or matter which he or she, being the commissioner, may deem it necessary for the administration of the act. So the manner in which Section 6AB is designed, Chair, is that it grants the Commissioner at discretion to publish these notices for a matter which, in the discretion of the Commissioner, is necessary for the administration of the Act. Chair, this is expressly provided for in legislation. The Commissioner proclaims in response to what the complaints have been, to the submissions coming from the stakeholders, that he is merely exercising the power which is granted to him by law, and the intention of exercising that power, the Commissioner claims in the notices, or letters in the notices, is to strengthen, to aim at strengthening the systems of internal controls by verifying bank account details and securing that payments that are made by the Commission go directly to the correct beneficiaries who have claimed against the Commissioner in terms of COIDA. Whereas the stakeholders, on the other hand, are contending that the notices themselves undermine the legislative authority of Parliament, and specifically clause 43.3 of the bill, which is currently before the committee. So that essentially is the issue here, Chairperson, of the stakeholders thinking that the notices in fact are ultra-virus, or the compensation commissioner overreached or exercised a power that he does not have, or he was not reasonable when he exercised that power when he published this notice. Whereas the compensation commissioner's view, on the other hand, is that I'm exercising a power which is expressly given to me by law. And
Sorry, Chair, on a point of order.
Hello.
Could we ask the presenter to speak into the mic, please, because we keep losing him?
Yes, I have observed that. That's a point I was raising earlier. Mr. Mjenxane, we keep on losing you. If you can speak on the mic here.
Yes, Chair. No, thank you. And I apologize
maybe because I don't know if your device is not being monitored as a person from that committee, that standing committee. We keep on losing you.
No, Chair, my apologies. And I will try to speak as close to the mic as possible.
Okay.
Chair, I don't know where members lost me, but I was at the point where I was trying to describe what the issue is between what the stakeholders contend and what the Commissioner's view is on the matter, as per the notices for which the stakeholders have complained against. So essentially, Chairperson, I was saying that the Commissioner's view is that he is publishing these notices in terms of the power expressly granted to him by law, and that in that section, in section 6, capital AB, the Commissioner is granted the discretion to publish such notices, Chairperson. So our analysis, Chairperson, of the matter, when we looked at the legal framework, whether to assess whether the Commissioner may have acted ultra vires, meaning whether the Commissioner would have exercised a power which he was not allowed in law to exercise, or whether there was any overreaching on the part of the Commissioner when he exercised this discretion in terms of section capital A. We went to look into the Principal Act, Chairperson, which delegates this power or grants this power to the Commission. The Act, Chairperson, is as I have read it to the members. It expressly grants this authority to the Compensation Commissioner to make the notices or to issue these notices, as long as it is within the parameters of that section. And the parameters of that section is, as I have read them, Chairperson, which end with granting the discretion to the Commissioner to exercise the issuing of these notices if it is necessary for the administration of this Act, which is the position which the Commissioner contends. And on the basis of that analysis, Chairperson, we then looked into the second aspect of the stakeholders' complaints, which is the fact that they are saying that by issuing these notices, the Commissioner has undermined the work that is currently before Parliament, which is that of amending a COIDA. Chairperson, once again, a bill that is being amended by a committee, or a bill which is currently being considered by the committee, is not considered to be law, Chairperson. It is not a source of law. And therefore, there is no way that the Commissioner may have considered this bill when making or exercising the power in terms of 6 capital AB, because this bill has not yet been passed. It is currently before the committee, and there is no guarantee that once the committee is considering this bill, all these sections which the commissioner, which the stakeholders are relying on, Chairperson, to challenge the commissioner, who will survive the amendment process.
Just a minute, Mr. Mjenxane. I see the hand of Honorable Dango.
Okay, Chair.
Just a minute.
Chairperson, I'm listening very carefully. I've got it. I just wanted to make a comment at the end.
Oh, okay. All right. Okay, you can then continue, Mr. Mjenxane.
Thank you, Chairperson. So I was at the point where I was stating, Chair, that the bill that is currently before the committee is not a source of law and could never have been considered competently by the commissioner in order to make a decision. The commissioner, as pointed out in the notices, Chairperson, exercise the power which is specifically granted in the Principal Act. So our advice then, Chairperson, which is the last paragraph of the short advice we've provided the committee, is that we could not see the reliance in law of the stakeholders that the commissioner may have overreached or acted ultra vires by publishing these notices. And certainly it is not apparent in our own scrutiny of the notices, Chairperson, the part where the commissioner, by exercising a power that is granted in law, is undermining the work that is currently before the committee. We were not able to find that in our own independent scrutiny of the relevant legal framework, Chairperson. And we therefore said we do not find any justifiable basis to justify the allegation that when publishing the notices, the commissioner was acting in bad faith or that he had ulterior motives of undermining the legislative process that is currently underway. We don't see how that would be possible in any way, Chair, because notices and regulations in themselves are subordinate legislation. And in law, Chairperson, subordinate legislation is, as the word suggests, subordinate to the Principal Act. And there is absolutely no way in the application of the law that when a national legislation is passed, some subordinate legislation would then go against such a law when such a law is passed. Because whatever subordinate legislation that is currently applicable, which is contrary to the law when it is published, it becomes that such subordinate legislation becomes invalid, Chairperson. So our conclusion, Chairperson, is that we could not find any justifiable basis for the allegations by the stakeholders. We, however, Chair, state that the committee has the power to invite the commissioner to appear before it, for the commissioner to express himself before the committee and assure the committee whether his exercise of the power granted in section 6 capital A, B, he exercised that power in bad faith or with ulterior motives of undermining the work of this committee. That essentially is our advice to the committee.
Thank you very much. Can I just also check whether I also send you an email from Honorable Boshoff. I don't know if your response also take into account the letter I sent to you to also give advice on it. It was actually a letter that was addressed to the Compensation Fund Commissioner. But then in terms of the content, I suggested that perhaps you give advice on it as well.
Yes, no, Chairperson, I also consider the
if you can
yes,
closer to your mic. Yeah, just talk to your mic here.
Yes, Chair. No, I was saying we have also considered the SICA submission to the commissioner, which is the South African Institute of Chartered Accountants, which essentially challenges the notices, Chairperson, along the same lines as the lines that those of COID link, which has approached the committee. Wherein, Chairperson, SICA also alleges that the actions of the commissioner are ultra vires and that they go against the principle and letter of what is currently before the committee, being the amendment of the COID. And Chairperson, we come to the same conclusions as it relates to this submission by SICA, that as it relates to the committee that is currently looking into this bill, There is no justifiable basis which point to any ulterior motives by the commissioner, and or that the commissioner acted in bad faith, and that as the notices proclaim, and through our own independent legal scrutiny of the applicable law, the commissioner acted in terms of a section which grants him that authority expressly in the Principal Act, which is section 6, capital A, B. I just want to state, Chairperson, which is probably an issue that I must just comment on in this regard. I just want to state, Chairperson, that in an instance, for instance, where a public power has been exercised by an administrator, in the current circumstances where a public power has been exercised by the commissioner by publishing notices, a party who is aggrieved by an exercise of such public power has basis in law to raise the issue with the decision maker. And the second option, Chairperson, of course, indicating, as SAICA has done, they are misgiving about the exercise of that power. The next available step in law, Chairperson, is to appeal the decision of the decision maker to the appellate authority within the confines of the Promotion of Administrative Justice Act, which is BAJA. Where an appeal is unsuccessful, Chairperson, it does not end there for a party that is aggrieved by a decision made by the administrator. The party can take the matter on judicial review for the court to review whether the decision maker acted reasonably and justifiably when he made a decision to publish this notice. So it is essentially a matter that cannot be ruled upon by Parliament at this stage, Chairperson, because the committee currently is engaged in amending COIDA and will certainly not be able to pronounce on the validity or invalidity of the power that is expressly given to the commissioner when the commissioner publishes this notice. And therefore, Chairperson, in summary, I'm saying SAICA was correct to direct the matter to the commissioner. And I imagine that where that matter fails, the engagement between themselves and the commissioner, SAICA will then proceed to appeal the decision of the commissioner to the Minister of Labor, subsequent to which they have an avenue of taking the matter on judicial. So that is my view on the matter, Chair. Thank you very much. So in essence, yes, we have covered in our advice the letter that you gave me this afternoon from SAICA, which is essentially not any different from that of COIDLink, which was submitted to the committee. Thank you, Chair.
Thank you so much. Just before members, Samara, you would like to say anything on the matter?
Thank you, Chairperson. Good afternoon, members and colleagues. Chairperson, indeed, I agree with my learned colleague. We have discussed the matter prior to this meeting. The issues raised by both COIDLink and SAICA are pertinent, perhaps not for the process that the committee is undertaking at this point. We can park the issue, and once this bill becomes an act, we can revisit it at that time, Chairperson. That would be my humble suggestion. Thank you.
Thank you so much. This stage, I would allow the members to comment. Honorable Dango, Honorable Boshoff, Honorable Moima, in that order, please.
Chairperson, in light of the advice given by the legal persons with us today, against the background of existing legislation, the Commissioner did not overextend his powers. The Commissioner had the right to do what he was doing, and the Commissioner acted within the law. With that being said, Chairperson, I want to say that I think we need to just dismiss what the applicants are saying and indicate to them that, in our view, at this particular point in time, and based upon the legal advice that we've got, at this particular point in time, that the Commissioner was correct in what he was doing. However, Chairperson, I was also a bit disturbed when we were interviewing when the applicants or the stakeholders who made these accusations were before the committee. They refused to answer questions as to how much margin they were making as debt collectors, and essentially they are debt collectors, not funders. Thank you very much, Chairperson.
Thank you very much, Honorable Tango. Honorable Bishop.
Thank you very much, Chair. Did I hear correctly when the presenter, I'm not going to try and pronounce his surname, sorry for that, said that SAICA can now appeal the process, or did I understand him incorrectly? And then I would just like to know, why are we saying that this bill has no sessions? We know that the Portfolio Committee of Employment and Labour amended, and then only did the regulations come out. And why did these regulations come out only after the bill was amended? I need some clarity on that, please. Thank you.
Thank you so much. Honorable Moga.
Thank you, Chair. Let me also take this opportunity to welcome the presentation from both Nati and also Shamila. Chair, the thrust of the presentation is that the principles of legality enables the commissioner to have done what he did because of the enabling legislation, which clearly says to us that the commissioner acted within the scope and powers of his responsibilities. He did not exceed it. His action is somehow enabled by law, more so in particular Section 6. So therefore, I want to move that we accept the proposals that the area raised can always be dealt with as a matters arising point. We could, as part and parcel of our monitoring and evaluation in future, after we have passed the legislation, we invite the commissioner to somehow understand the workings of the notices if such a need arises. Thank you, Chair.
Thank you very much. Can we allow then Nati to respond?
Okay, before, may I just have a follow-up question?
Okay.
Thank you very much. Could I also be informed, the first notice that was gazetted in September was dismissed and it was again gazetted in October. Why was this done? And could we have an explanation on that? Thank you very much.
Thank you very much. Mr. Mjenxane.
Thank you once again, Mr. President. Just the first question by Honorable Bishop relating to the issue of the appeal. I just want to say, Chairperson, with the greatest of respect, that I, as a legal advisor, would not be able to competently advise SAICA about its legal options under the circumstances. However, I am commenting just as a lawyer, Chairperson, to say that in terms of the Promotion of Access to Justice Act, where a competent authority, where a decision is made, which is an administrative action, an exercise of public power, and a party is aggrieved by the exercise of that power, the party can appeal Now, if it is the commissioner who has made this delegated decision to him by the legislation, the next step of appeal would be the Minister of Labour to say that SAICA is aggrieved by the decision of the commissioner. If the minister in the decision, in looking into the decision of the commissioner, comes to the same conclusion as the commissioner or supports the decision of the commissioner, then SAICA can take the minister on judicial review. Those are options that are available to SAICA chairperson. As just a general comment as a lawyer, I'm not advising SAICA. I'm sure SAICA can get much more competent advice in respect of its options in law. All I am advising the committee chairperson as a legal advisor to the committee is that the SAICA complaint to the commissioner cannot be competently dispensed with by the committee because the committee does not have that authority in law. That's the first advice I'm giving the committee. The second advice in respect of this chair that I'm giving the committee is that the bill, which is referred to in the SAICA complaint as well as the Coitlin complaint, is currently underway, and that in its current form, it is not law. And there is absolutely no way competently in law where a bill can be used to come to a conclusion. If the commissioner may have published his notices just after the portfolio committee had adopted this bill, and that was the reason for the commissioner, as it seems, to appear in the complaints and what Honorable Boshoff is asking, the commissioner would then have been misled, Chair, to do so because the process of amending legislation is not complete. This is why this bill is currently before this committee. For all we know, Chair, this committee may come to a completely different conclusion to the conclusion of the portfolio committee. And it would then have been putting the cart before the horse if the commissioner had anticipated anything different, Chairperson. So that's why I'm saying that it would be an anomaly in law for someone to make a decision on the basis of a bill that is currently still being amended and not passed by Parliament. So that is my comment around that. On both the regarding the appeal by SAICA and also the fact that it appears as if the exercise of the discretion that is set out in Section 6, capital A-B of the COIDA currently, Chairperson, was done so after the portfolio committee passed or adopted the bill. And lastly, Chairperson, on my side, I also just want to say, as per our advice, the committee has sufficient authority to invite the commissioner to appear before it, for the committee to direct these questions to the commissioner who made this decision of publishing the notices, and the committee to satisfy itself on whether the commissioner had, number one, had ulterior motives when he published the notices, or whether he acted in bad faith. So that in essence is our advice. Thank you.
Thank you very much again, Mr. Mjenxane. On the issue of meeting with the commissioner to clarify some of the issues that members are raising, including the Honorable Boshoff about the date in September, I think the other one in October. I suggested to Madia, the committee secretary, that next week, once we will be considering the two reports, one on the employment equity and other one on the compensation bill, we will also be meeting with the department. It's a scheduled meeting with the Department of Employment and Labor on the annual report, I think 2020-2021 annual report. But I had suggested to Madia that the commissioner should also be invited just on this particular issue as a suggestion and advice of the legal advisor, that we also be seen as a committee that we've done our part in terms of dealing with this particular issue. So meaning that next week on the 22nd, there will be three issues. The consideration of the reports on the two bills, the annual report, and also the meeting with the commissioner on this issue of the notices, including the points that are raised by Honorable Boshoff on the on the date of September, date of October, and also whether there were any ulterior motive in giving out this notice immediately after the portfolio committee had agreed on the on these particular clauses or sections. Can we agree on that? That we don't delay this. We have it as part of next week's meeting.
Honourable Chair, a point of order.
Yes.
Could I then also ask, on the 2nd of February, the Compensation Commissioner or the fund, they had a meeting with the Portfolio Committee, and 75 submissions were made, and the Commissioner promised that before the end of February, they would receive feedback, and no feedback has been received. Will he give us the feedback at the meeting next week? Thank you.
Sorry, can you repeat, Honourable Bosho?
At a meeting held on the 2nd of February with the Employment and Labour Portfolio
Portfolio Committee.
That's right.
Okay.
I've gone through all of the presentations just to be prepared for today, and the Commissioner said that he would respond to the 75 submissions that were made before the end of February, and up until to date, they have not received a reply on those 75 submissions. So we need to know what those 75 submissions were and what the reply was as well.
Well, I don't know anything about it. So you say that it's something that happened in the Portfolio Committee, not in the Select Committee.
Makes no difference, Chair. We work hand in glove, and we need to know what the one hand is doing together with the other hand. Thank you.
No, Honourable Bishop. We decided on our own program as a Select Committee when to invite the department, on what issues we invite the department for. So we don't even know, I don't even know what you're talking about. But let's just focus on the issue that was a complaint from a court link, but also I decided that the issue that comes from this other organization be part of the legal advice as well. So I suggest that we focus on that. We invite the compensation commissioner on
that one.
Honorable Dodovu, can you please mute?
Chairperson, can I just raise the one point?
Yes, okay.
I want us to make sure that this process is not contaminated, precisely by virtue of the fact that many stakeholders heeded to our public consultative processes. They have made representation. The department have responded to them. We are making decisions on those presentations. My biggest worry is that as we are in a process of taking a decision and then consideration, it becomes important that this process must be separated. If I had my own way, I would suggest that let's have a discussion with the commissioner after this process has been adopted by Parliament, so that we should not create an impression that to other stakeholders that made public comment on these two bills, that we are opening a floodgates for further engagement with them. Thank you, Chair.
Thank you very much, Honorable Moima. Now we are clear, I think, as a committee that this issue is not going to impact on the processes of lawmaking or dealing with this particular bill. We're going to continue with the processes of this particular bill, but the issue that will be engaging the department or consulting the department on is just issues of clarification, not that you will be instructing the department to do A, B, C, D, but just clarities for the purposes of information for the committee. You can't instruct, as the legal advisor is indicating, we can't instruct the department, but we will deal with our processes because we're not bound by the notices. We have our own processes. We can make amendments even to the portfolio committee proposal or amendments. That is not going to have an impact on the notices itself, as he's suggesting that if the parties are not happy, because the other problem is that even with the employment equity, there's a letter that was sent to us by another stakeholder. I mean, the process is that we get a briefing from the department on the legislation, or if it's a legislation that comes from the ministry or department, and then we advertise and we get submission. We indicate to the parties if they want to come and do oral presentations. Those that will agree to come and do oral make an oral presentation, then they come. And then the department responds. But now there would be parties that are not happy with the responses of the department, and they want to write to us as a committee. And now it means that again, you must ask the department to respond to their second submission. I mean, it's gonna go on and on. So we need to indicate, perhaps, maybe it's a matter that when we have public hearings, the first thing that we must indicate to the parties that when they come and make oral presentation and then the department respond, it doesn't mean now they have another opportunity to oppose what the department says. They should leave it up to the committee to make its own decision on the issues. And then the matter will then go to the House. And then if the House adopts the report of the committee, it's passed. If they're still not happy with the House having adopted the bill, and then the bill goes to the president, they can also go to the president and write to the president and object if they're not happy with the bill. So this thing of writing to members, sometimes individually or to the chairperson, after they have had the opportunity to make their submissions, and if they are not happy with their submission, it doesn't mean now must again listen to their submission. Their opportunity has passed. They must leave it to the committee to decide how it deal with the process of lawmaking. There are other avenues for stakeholders to make their further submission if they are not happy with the processes. So I just wanted to indicate that aspect. Otherwise, we are going to now continue with the process. We have received the legal advice. We decided that we will invite the commissioner, but it doesn't have an impact on the bill processes that we are embarking upon. We will either adopt the reports next week or reject the reports next week. So it's up to the committee still. Honorable Dango. I see your hand is up.
It is an old hand, Chair.
Oh, okay.
It's been there for quite some time.
All right. Oh, it's all right.
It's a legend hand, Chairperson.
Oh, okay.
Ms. Matia, your summary is correct.
All right. Thank you so much. Ms. Matia, can you then please flight compensation fund maybe I suggest that you start on page slide. Let me just check. Slide 37.
Chair, I've actually asked Enrico to just flag the presentation and he's ready to go. Enrico, if you can just go to the query
Slide 37, yeah. Go to slide 37 on record, please. Okay. Can you have it as a slideshow, please? Okay. Can you go to the next page, our slide? Okay, there where we start, honorable members, as I indicated earlier, we'll first focus on the areas where stakeholders had their submissions and also the response of the department on those areas. The first one is BUSA, Business Unity South Africa, amendment on the definition of accident. That will be section 1 of the bill. If we could have a comment then from members.
Chair, can I speak, Chair?
Yes, you can.
Chair, I think we take note of the issues that were canvassed by BUSA, but my view is that the clarification and response that was given by the department is sufficient enough to allow us as a committee to say that let's accept the response as given by the department in response to the issues that were canvassed by BUSA. Thank you. Particularly on this issue of definition and incidents and occurrence. Thank you. But also including the 4 areas that they are raising here around an approach to respond to issues that are raised by BUSA on the amendment of the definition of an accident. Thank you, Chair.
Any other members? I think the issue there is the word "and" and the replacement with "or." BUSA says they're proposing "or." Otherwise, the content is the same in terms of the definition. They say the accident means an incident or occurrence arising out of or, that part, I'd say out of or. The department says out of and. You see where the difference is. So otherwise, everything else is fine. The only difference is that arising out of or in the course of employees' employment. So it's the issue is around and or. So what you're suggesting, Honorable Moimang, is that we accept the word and instead of the word or, if I hear it correctly.
Honorable Chair.
Yes, Honorable Bishop.
Please note that the DA is reserving its position on that.
Okay, noted. Okay, can we go to the next one, Enrico? Okay, that's what the department is suggesting, which is being agreed. But we're still going to go to the bill again in terms of voting. Honorable members, we will be raising our hands and count the number of those who are voting for or against in terms of the rules of the committee. For now, we just checking if we agree or disagree. I see there. I don't see whose mic is on, but I see there are people that are conversing. I don't know if the hands are all hands. I see there are 3 hands.
They are legacy hands, Chair.
Oh, okay. Can I request that it be lowered? Can we move to the next slide, Honorable Enrico? Then there's section 4. Section 4 is on the transfer of Directors General administrative power to the Commissioner. Any comments there? Say, Busa's further submitted that there are inaccuracies with regard to the transfer of Director General administrative powers to the Commissioner. The word Director General still appear in instances where it must be replaced by the Commissioner. So then the department is responding on the right-hand side that this was also agreed upon at NETLAC in order to avoid human error. The Office of the Chief State Law Advisor advised on the need for the omnibus provisions in clause 62 of the bill, not section 62. The clause heading is substitution of certain expression in Act 130 of 1993. Relevant for this purpose is clause 62D, which reads as follows. D, by the substitution for expression Director General wherever it occurs of the word Commissioner, except in section 1, 18, section 30, section 50, section 55, and section 69. So those areas will still be, in terms of expression, be Director Generals, section 1, section 18, section 30, section 50, and section 55, and section 69, but all others will be Commissioner instead of Director Generals. I think that's in simple terms of what it means. Any comments?
Honorable Chair, can you hear me?
Yes, yes, Honorable, for sure.
Once again, we reserve our opinion in this regard. Thank you. Our position.
Thank you so much. Okay. Any comments, honorable members, other than Honorable Bishop has indicated?
So from my side, the clarity as given with regard to the issues at hand, particularly in view of the transfer of the Director General's administrative powers to the Commissioner. I think the first and foremost, what is quite clear is that there was consensus at NETLAC, though not overlooking the fact that it does not mean that if parties agreed at NETLAC, they can raise issues with regard to the lawmaking processes when it is tabled either before NA or the State Committee. But I think what is quite critical for me is what is contained with regard to clause 62D as outlined by the department, particularly on the bullet point number 3. So therefore, it's quite clear as stated here, where there will be point of proviso in section 1 and section 18, section 30, section 50, section 55, and section 69. So therefore, the responses given by the department does make sense.
Thank you so much. Are there any other comments? Not. So can we move then to the next slide? Amendment section 69. Section 69 deals with the notice period for Schedule 3 and penalties. It says Busa further proposed that notice period of the amendment of Schedule 3 should be 60 days rather than 30 days. Busa proposed that the penalties should be expressed in monetary terms rather than percentages, and that bill must still provide for offense to be imposed by courts. And then the department is on 30 days notice period before amending Schedule 3 of the Act. Okay, Clause 39 amends section 69 and provides for government notice to be published at least 60 days before amending Schedule 3. So this is in line with the BUSA submission on the matter. So on the issue of the period, department agrees as well to BUSA submission. I think it's a matter that was also agreed at NETLAC level. If I'm correct.
Agreed on this one, Chair.
Yeah, but then on the issue of penalty, the difference is that the BUSA proposed that the penalty should be on monetary terms rather than on percentage. The department say the issue of the percentage was agreed at NETLAC, that is 10%, and the rest of the clauses. Honorable Dango, with the old hand.
It's not an old end, Chairperson. I think we agree with the department on this particular matter, particularly the issue of monetary terms versus percentages. Percentages is flexible. Monetary terms is fixed.
Okay.
Thank you.
Honorable Boshoff.
Thank you, Chair. For the sake of time, note that we will reserve our position on every take of the department. Thank you.
Thank you. But for the purposes of recording, we'll have to ask you again if you please just so that we are recorded. I had wished that these sections were following each other logically instead of 69. There's also 30. Can we go to section 30? The next one, Enrico. Oh, there's 70 as well, and you still have 70. So they're not logical. They are based on the submission of the stakeholders. Okay. On 70A, COSATU is proposing that the insertion of section 70A is, if enacted into law, it will restrict the injured employees to their previous employment and will not empower them to perform work either as independent contractors or be self-employed. And the response of the department believes that the ambit of the proposed section 70A is wide enough to assist the injured employee to perform not only the work he or she was doing at the time of the accident or contraction of the disease, but also to be rehabilitated to engage in other economic activities such as independent contractor or self-employment. The regulations and policies on rehabilitation will provide for implementation of section 70A. Maybe I must deal also with 70A1. COSATU further submitted that the section 70A1 must provide for mandatory provision of rehabilitation facilities, service and benefits. The department's response is that the discretionary use of may is linked to the incentive to employers who participate in rehabilitation programs on the reductions of or premiums or assessment that employers must pay annually. This is likely to get a buy-in from employers than the mandatory provision. Can we start with the 70A, honorable members? 70A, 1C.
Okay. Can I propose that if you can move to the next slide? Just want to check something.
Okay.
On the page, yeah.
The next page talks about the licenses, issuing of license.
No, it's fine. Let's go back.
Yeah, so that's why I was saying that because it's a section 30. So logically, it should have been when we were dealing with section 18, immediately after section 18, we should have dealt with section 30. And then 69, and yeah. But then here they are in terms of the submission by organizations. So what is our take on this one?
Thank you very much, Chair. I reserve my position.
Thank you so much, Honorable. Bosho,
Chair, I think we accept the department's position.
on 70A with its subsections,
Correct,
including
Chair.
the issue of the mandatory provision of rehabilitation,
Yeah.
the discretionary use. Okay. The next one is the licenses issue that Honorable Mjenxane wanted to comment on. I wanted to check the clarity on. This one deals with the issuing of licenses in terms of Section 30. COSATU raised a concern that the issuing of licenses to the licensees might fall in the hands of insurance companies who may deprive the employees of benefit on the basis of technicalities. Section 37, COSATU raised a further concern that how the operation of license will be supervised to ensure that workers' claims are not inappropriately rejected. Then the response of the department that the license in their current form already contain built-in mechanisms for monitoring of the licensees, and that in addition to the conditions prescribed by the minister, the DG is empowered to determine the conditions for provisional settlement of the claims. Or in other words, the DG will have to confirm the decision taken by the licensee before they are regarded as final. This is in terms of Section 62 read with the Section 45. Any comments? Okay, let me also read so that we comment on the whole section.
Can I just raise something, Chair? I think maybe we'll advise because there are other meetings that are taking place after this one, and it might affect the quorum. I suggest that probably what we need to do, we need to find a way to also manage time so that the meeting does not collapse as a result of those that might be moving towards Parliament around.
Okay,
6.
all right. Maybe what I should just say, because we are almost we are left with I think we're almost maybe let me just call out the section without necessarily reading the content, and then ask members whether they agree with the stakeholder or they agree with the department. Is that fine?
That will assist a great deal, Chair.
Okay, so we are on Section 30.
We agree with the responses given by the department in response to the issues as canvassed by COSATU, Chair. Thank you.
Thank you. Honorable Bosho.
We again reserve our position. Thank you.
Okay.
Honorable
all right, maybe because in the House we will deal with parties. Let me just check if there are any other parties. Is the EFF present? Honorable
Yes, Mr. Aplenny was logged in earlier, Chair.
He's no longer logged in.
No, I don't see him anymore, but he did log in at the beginning of the meeting, but I think we might have lost him, Chair. No, he's still here. No, he's not. Sorry, Chair, he left.
No, it's Temgosi Mkhalipi. I also thought it was Temgosi Aplenny. Okay, can we go to Section 73? This one deals with the third-party registration. Oh, sorry, it's my problem. The way I listed them, they are logical, but sorry, it's Section 18. Sorry, Enrico. Section 18, can we have comments? Agree with the
Chairperson, we agree with the department's response.
Agree with the department. Honorable Musheri.
Good afternoon, Chairperson. We agree on the department on this one, Honorable Chair. Thank you.
Thank you so much. Honorable Bosho.
Thank you. Reserve my position. Thank you.
Thank you so much. Okay, the next one. Okay, this one is that Section 73, which is the clause 43. Any comments?
Reserve my position. Thank you, Chair.
Thank you, Honorable Bishop.
Agree, Chair, with the clarity given by the department on clause 43 and its provision in relation to the issues canvassed by Link. Thank you, Chair.
Thank you so much. Next slide, Enrico. Oh, that was it.
Thank you.
Now, what we need to do then is to look at the bill, honorable members, because as I was indicating earlier, we're focusing now on those areas where parties had submissions, and the department was, or the commissioner, or the competition commission was, was responding to. But now we're going to the whole bill, because also in the bill there are amendments that are not necessarily having the submissions from the stakeholders. But also on this one, we'll take the same approach as advised.
That's for record purpose, Chair. Compensation Commissioner, not competition.
Yeah. We're also dealing with competition commission as a committee. Sorry. Yeah, compensation for occupational injuries and diseases amendment bill. If we have, yeah, thank you so much. Is it the B21? Okay. I think firstly we'll have to agree with that page.
Agreed, Chair, for the page.
And
which covers, which gives the clarity on the bill that we're dealing with, and also as it is marked Bill 218.
Okay. The purpose of the bill. Any comments on the purpose of the bill?
Chair, again, I reserve my position. Thank you.
Thank you so much. Okay, now we'll deal with the clauses. Clause 1 on page 2. Agreed.
Agreed, Chair.
Honorable Bishop.
Reserve my position. Thank you.
Okay. Let's go to clause 2. Clause 2 will be on page 5. You go to page 5. Yeah, clause 2. Clause 2 deal with section 4.
Chairperson.
Honorable Tim.
Yes, thank you, Chairperson. Are we required to vote by province, or can we vote by party?
As individuals in terms of section 75.
Oh, okay. All right. Yes. Well,
as individuals.
Do you need my vote in each of these sections then?
Maybe what we should do then, if going back to maybe the bill, maybe let's start fresh. Let's go to the first page. And
I'm happy to stay. I'm happy to allow my colleague to speak for us, but I just want to know if we're doing it correctly. That's all.
Now let's do it correctly. Let's vote on clause by clause, including the first page, so that we don't have challenges on the issue. Can we raise a hand that we agree with the cover page by raising our hands?
Honorable Chairperson, Honorable Mushudi agree.
Okay.
I have raised my hand, Chairperson, on the screen.
Yes, I see your hand. Can you count for us, Madia, and also include the Honorable Mushudi's hand?
Yes, Chair. Chair, including Honorable Mushudi, we have 5 members who have agreed. So we have Mr. Moimang, Mr. Duduvo, Mr. Dango, and yourself. And then we've got Ms. Honorable Mashodi who have agreed.
Okay, no, thank you so much. Can we then go to the next page on the purpose of the bill? Can we vote on that one?
Chair, what about us that reserve?
Oh, sorry. Sorry, thank you for reminding.
Yes, yes.
Sorry for reminding. Can we lower the hands? It's been a long day. Can we lower the hands, Honorable Dango, those who have voted?
Mama Rekhane wanted to be admitted to the platform, but with a different number. I don't know whether was that matter sorted out.
We did admit her, Honorable Mjenxane, but she keeps, I don't know if she's got a network challenge, but she keeps coming in and out of the meeting. But we keep admitting her as she comes in, Honorable Mjenxane.
Thank you.
Those who are voting against on the page. You help me again, Ms. Martin.
Yes, Chair. Just for clarity's sake, Honorable Bashaf and Honorable Broadsev have both raised their hand. I just want to check for the record, are they voting against or are they reserving their position on the cover page?
Honorable Chair, through you, we are reserving our position on everything.
Okay. Maybe let's for now lower the hands and then I'll call for abstentions. You can lower your hand, Honorable Tim, so that I check if there are any who are voting against. No. Those who are abstaining. Then you can raise your hands on the abstention. Because I take it that abstention and objecting would be the same. Or reserving, you'll be abstaining in a way. Am I correct, Ms. Williams?
There's quite a difference between abstaining and reserving a position, Chair.
That's what I wanted to check with Ms. Williams as well, and Samara. Samara? No, they're not here.
Last minute.
Okay, let's take it that you're reserving your...
Chair, it's Shimara.
Yes.
Apologies, Chair. It takes a bit longer in the afternoons to unmute. Chairperson, when a party abstains, they neither agreeing nor rejecting the point that's put forward. It's very similar to reserving their point because they're not taking a decision. Does that perhaps assist?
So abstention and reserving, is it the same?
That's correct, Chair, because the party is not pronouncing itself in terms of the decision required. It's neither yes, no, a no.
Okay. No, I think it's...
May we come in there then?
Yeah, so it's abstention. So we have two.
We are against.
Oh, you are against. Oh, okay. No, that's fine. All right. Any abstentions?
Okay, I see Honorable Broadse's hands up.
And yours as well. Yeah? So,
I think Honorable Broadse wants to say something.
oh, okay. All right.
No, just to agree that on page 1, the KZN is against.
Oh, on the cover page.
Yes.
Okay.
So, Chair, can we just be clear from now on that we will vote under against?
On the cover page?
Yes, and all the subsequent sections.
All the subsequent. So we'll just note that in terms of the record, is that what you suggest?
Yes, Chair. So if we can just change it from an abstention to against on this particular one and then go forward. Okay. And then you can call for 4 against and abstentions. We will vote accordingly.
Okay. Samara, is that correct?
Chairperson, that's in order.
Okay, no, thanks. All right. But I think we will do it that way then. We had already done so with regard to the object of the bill, the purpose, sorry, of the bill. We have voted on that one. Then on clause 1, those in favor, can you raise your hands? Clause 1.
Honorable Mshodi must add that, Honorable Chairperson, I'm in favor.
Okay. Can you help us, Ms. dear?
Count me
Yes,
in,
Chair.
Honorable Chair.
Okay.
Chair, in favor, Chair, we've got yourself, Honorable Mashodi, Honorable Moimang, Honorable Duduvu, and Honorable Dango.
Okay. And we can lower the hands, and then you will record that the 2 are against. So it's 5 in favor and 2 against. Then let's go to clause 2, which is on page 5. It deals with section 4. Those in favor?
Thank you, Chair. In favor, Honorable Mshodi.
Okay. So 2 against. So how many in favor, my dear?
In favor, Chair, we've got 5, including Honorable Mashodi. We've got yourself, Honorable Moimang, Honorable Duduvu, Honorable Dango, and Honorable Mashodi. So we've got 5 members in favor, Chair.
Okay. Can we please lower our hands? I don't want to take for granted that legacy hands are also voting for the next clause. Honorable Dango, can you vote on a legacy hand? Clause 3 is on the same page. Those in favor of clause 3, please raise your hands.
In favor, Chair. Honorable Mshodi, thanks.
Okay. You help us again.
Yes, Chair.
Check
Chair, I don't-
Honorable China there.
That's why we didn't want a legacy hands.
Yeah. Chair, in favor, we've got 4 hands. We've got yourself, Honorable Dango, Honorable Moimang, and Honorable Mashodi.
And against? Oh, there's a Honorable.
And then
Duduvu.
Honorable
Chair,
Duduvu.
I'd raise my hand. Count me
Okay.
in. I'd raise my hand.
Yeah,
I'd
noted.
raise my hand, Chair. Count me in.
Noted, yes. Okay, we can lower our hands now. Can we record then the 2 against Honorable Matia?
We'll do so, Chair.
Okay. And then we go to clause 4 on page 6. Those in favor? I didn't lower my.
In favor, Honorable Chairperson. Thank you, Honorable Mshodi.
Okay. Ms. Matia?
Chair, in favor, we've got Honorable Dango, Honorable Duduvu, Honorable Moimang, yourself, and Honorable Mashodi. So we've got 5 in favor, Chair.
Thank you very much. Can we please lower our hands? Let's lower our hands. Yeah, I didn't lower me. It's happening. Okay. Honorable China Dodov, can you please lower your head? Okay. Clause 5. In favor? Can you please raise your hand?
In favor, Chair. Thank you, Honorable Mshodi.
Okay.
Honorable Dodoro doesn't quite know whether he should vote or not.
Okay, we'll count those that have raised their hands. You'll help us, Honorable.
Yes, Chair. Yes, Chair. Those who I'm counting Honorable Mashodi, and then yourself, Honorable Moimang. Sorry, I'm just Honorable Dango and Honorable Duvo. I think
Dovu.
Duvo,
And
yes.
Honorable Dovu.
Okay. So you record. So on each clause, you'll indicate how many that have voted for, how many have voted against in terms of the records.
Yes, Chair.
Okay. Clause 6.
Chairperson, Honorable Mashodi in favor.
Okay. How many have voted in favor?
Chair, I think there's a bit of a delay. Okay, here we go. In favor, we've got 5 members: Honorable Duduvo, Honorable Dango, Honorable Moimang, and yourself, and then obviously Honorable Mashodi. So we've got 5 in favor, Chair.
Okay. Then, obviously, then against, we've got 2 members against. Let me. Can you keep on checking if Honorable Ablane is back, so that we don't leave him out of the
Not
process?
yet, Chair. Yeah, not
Okay.
yet, Chair. Not
All
yet.
right. We go to clause 7 on page 7. Those in favor?
Thank you, Chair. Honorable Mashodi in favor. Thank you.
Okay. You'll help us.
Yes,
Ms. Madi?
Chair. In favor, we've got Honorable Mashodi, yourself, Honorable Duduvo, Honorable Moimang, and Honorable Dango.
Okay. Let's lower our hands. Can we please lower our hands? Let's lower our hand, please. Don't want the legacy hands to vote. Honorable Dedov, can you please lower your hand? I think this system is a bit slow. Clause 8. Let's raise the hands in favor of clause 8. Those who are in favor.
Honorable Mashodi in favor, Chair. Thank you.
Okay. Ms. Matia?
Yes, Chair. Like I said, I think there's a bit of a delay in terms of the hands reflecting, but we've got 4 so far. Now we've got 5. We've got Honorable Mashodi, Honorable Duduvo, yourself, Honorable Dango, and Honorable Moimang.
Thank you so much. Can we please lower our hands? Okay. On clause 9, you also remind me because I may get confused. Clause 9, eh? Is that correct, Mati? Clause 9.
Yes, Chair.
Okay. Those in favor, please raise your hands.
Honorable Mashodi in favor, Chair. Thank you.
Chair, so in favor, we've got Honorable Mashodi, Honorable Duduvo, Honorable Moimang, Honorable Dango.
Maybe for record purposes, Ms. Matia, you should also indicate against 2 and abstention 0. Yeah, in that order.
Well, okay, we'll do so.
Of reporting. Yeah.
We'll
Can
do
we
so,
then
Chair.
lower our hands, please? Honorable Dodovo, can you please? Okay, thank you. Clause 10.
Mashodi in favor, Honorable Chairperson. Thank you.
Okay.
Okay, Chair.
Yes.
Yes, Chair, in favor, we've got Honorable Duduvo, Honorable Mashodi, Honorable Dango, Honorable Moimang, and yourself. And against, we've got Honorable Boshop and Honorable Prataseth.
Okay. Against?
Against, as indicated, Chair, we've got Honorable Boshop and Honorable Prataseth.
Abstention?
Now, for the record, no abstentions, Chair.
Thank you so much. Let's lower our hands, please. Can we please lower our hands, Honorable Moimang? Thank you so much. We go to clause 11 on page 8. Those in favor of clause 8, can you please raise your hands?
Honorable Mashodi in favor, Chair. Thank you.
Thank you so much.
Okay.
Yeah.
Yes, Chair. In favor, we've got Honorable Mashodi, Honorable Dango, Honorable Moimang, yourself. Yeah, I don't know if there's a delay on this, if the Honorable Duduvo as well. So we've got 5 in favor. Against, we've got Honorable Boshoff and Honorable Prataseth. For the record, there are no abstentions.
Thank you very much.
Chair, just a moment of clarity.
Yes.
Thank you, Chair. I note now for the last 2 votes that Madia has been recording our vote against, but she hadn't been doing it before. Am I assuming that our vote is being logged as against for every single one of these right from the beginning?
We are
No, I take from the point that you were raising earlier that
Yes.
Going forward, so they will be recorded as such. I just reminded.
That's fine, Chair. That's fine. Thank you.
So all of them, in fact, there will be a template that will also be attached to the report indicating in terms of clause by clause. Madiane?
Yes, Chair.
Yes.
Thank you, Chair. That's all. I just wanted to confirm that. Thank you.
But there should also be a column for the abstention, Ms. Madia, please.
Yes, Chair.
Yeah, Chair, I think that what we're doing now in the last 2 clauses is correct. So I thank you for that. Thanks a lot.
Thank you so much. Okay. Now I'm a bit lost. Which clause? We've done 11, eh?
Yes, Chair. I think we're going on to clause 12 now.
Clause 12, yes, on page 8. Those in favor of clause 8, can you please raise your hands?
Honorable Mashodi in favor, Chair. Thank you.
Thank you.
Chair, okay, Chair. In favor, we've got Honorable Mashodi, yourself, Honorable Moimang, Honorable Dango, Honorable Duduvo. And then against, we've got Honorable Boshop and Honorable Prataseth, and there's no abstentions.
Thank you so much. Can we please lower our hands? Thank you so much. Clause 13.
Honorable Mashodi
Those in favor, can you please raise your hands?
Mashodi in favor, Honorable Chairperson. Thank you.
Thank you so much.
Okay, so Chair, for the record, in favor, we've got Honorable Mashodi, we've got yourself, we've got Honorable Dango, we've got Honorable Duduvo, and we've got Honorable Moimang. And for the record, against, we've got Honorable Boshop and Honorable Prataseth, and no recorded abstentions.
Okay. Can we please lower our hands? Honorable Dango and Honorable Moimang, can you please lower your hands? Thank you. Clause 14. Those in favor of clause 14, can you please raise your hands?
Honorable Mashodi in favor, Honorable Chairperson. Thank you.
Thank you so much.
So Chair, for the record, in favor, we've got Honorable Mashodi, we've got yourself, Honorable Dango, Honorable Duduvo, Honorable Moimang. And for the record, against, we've got Honorable Boshop and Honorable Prataseth, and no recorded abstentions.
Thank you so much. Let's all lower our hands. you. Was that clause 14 that we've done? Let me use a pen to tick because I get confused. Can we go to clause 50? Was it 14 that we've done? Or was it 13?
I think it was Shumara, you'll have to correct me because I'm focused. I think it was clause 14, Chair, if I'm correct.
Oh, okay. Okay, let me tick. Can we do clause 15? Those in favor of clause 15? Can you please raise your hands?
Moshodi in favor, Honorable Chairperson.
Okay.
So, Chair, for the record, in favor, we've got Honorable Moshodi, Honorable Dango, Honorable Moimang, we've got yourself and Honorable Duval, and against, for the record, we've got Honorable Boshoff and Honorable Proudeseth, and no recorded abstentions.
Thank you. Can we please lower our hands? Am I audible? Oh, I am.
Yes.
Yes, you are, Chairperson.
Yes,
Oh,
Chairperson, you
okay.
are.
I see there's a delay in terms of lowering the hands.
It's exhaustion, Chair.
I know. It's a procedure, unfortunately. Honorable Todov, can you please lower your hand? Thank you so much. Now we're on clause 16. Those in favor of clause 16, can you raise your hands?
Honorable Moshodi in favor. Thank you, Chair.
Thank you.
Okay. So, Chair, for the record, in favor, we've got Honorable Moshodi, Honorable Duduvo, yourself, we've got Honorable Moimang and Honorable Dango. And then for the record against, we've got Honorable Boshoff and Honorable Proudeseth, and no recorded abstentions.
Thank you very much. Can we now go to clause 17 on page 10? Those who are voting in favor, can you please raise your hands?
Honorable Moshodi in favor, Chair. Thank you.
Thank you so much. Ms. Madia.
Chair, just for the record, it's not, yes, sorry. So it's clause 17. So recorded in favor, we've got Honorable Moshodi, Honorable Duduvo, Honorable Moimang, Honorable yourself and Honorable Dango. And against, we've got Honorable Boshoff and Honorable Proudeseth, and no recorded abstentions.
Thank you so much. We go now to, can we lower our hands, please? Thank you so much. We're now going to clause 18. Those who are in favor of clause 18, can you please raise your hands?
Honorable Moshodi in favor, Chair. Thank you.
Thank you so much.
So, Chair, in favor, we've got Honorable Moshodi, Honorable Duduvo, Honorable Dango, we've got yourself, and we've got Honorable Moimang. Registered against, we've got Honorable Boshoff and Honorable Proudeseth, and no recorded abstentions.
Okay. Can you please lower our hands? Okay. Let's go to clause 19. Those in favor of clause 19, can you please raise your hands?
Honorable Moshodi in favor. Thank you, Chair.
Thank you very much. Ms. Matia.
Yes, Chair. Chair, are you voting, Chair? I don't know if there's a delay on the system.
Oh, you. Sorry. I forget. I'm doing two things. I'm chairing and voting.
Okay, so Chair, in favor, we've got yourself, we've got Honorable Moshodi, Honorable Moimang, Honorable Dango, and Honorable Duduvo. Against, we've got Honorable Boshoff and Honorable Proudeseth, and no recorded abstentions.
Okay. Can we please lower our hands? Honorable Dango and Honorable Moimang. Thank you. And we go to clause 20. Those who are voting in favor of clause 20, can you please raise your hand?
Honorable Moshodi in favor, Honorable Chairperson. Thank you.
Thank you so much.
So, Chair, for the recorded, for the record, in those members in favour, we've got yourself, we've got Honourable Mashodi, Honourable Dango, Honourable Duduvu, and Honourable Moimang. And against, we've got Honourable Boshoff and Honourable Proudaseth, and no recorded abstentions.
Thank you so much. Can we please lower our hands? Thank you so much. We go now to clause 21. Can we, those who are in favor of clause 21, can you please raise your hand?
Thank you, Chair. In favor, Honorable Mashodi.
Thank you.
So, Chair, for the record, those members in favour, we've got yourself, Honourable Mashodi, Honourable Moimang, Honourable Dango, and Honourable Duduvu. And against, we've got Honourable Boshoff and Honourable Proudaseth, and no recorded abstentions.
Thank you so much. Can we please lower our hands? We're now going to clause 22. Those who vote in favor of clause 22, can you please raise your hand?
Your Honorable Mashodi, thank you, Chairperson, vote in favor.
Thank you so much.
So, Chair, recorded in favour of those members who have voted in favour, we've got yourself, Honourable Mashodi, Honourable Moimang, Honourable Dango, Honourable Duduvu. And against, we've got Honourable Boshoff, Honourable Proudaseth, and no recorded abstentions.
Okay. Can we please lower our hands? Okay. We're now going to clause 23. Those who are voting in favor, can you please raise your hands?
Honorable Mashodi in favor, Honorable Chairperson, thank you.
Thank you so much.
So, Chair, those members who have voted in favour, we've got yourself, Honourable Mashodi, Honourable Duduvu, Honourable Moimang, and Honourable Dango. And those members who have voted against, we've got Honourable Boshoff and Honourable Proudaseth, and no recorded abstentions.
Thank you so much. Can we lower our hands? Honourable Dango, can you please lower your hand? And please switch on your mic, switch off your mic before you say something that you were not supposed to hear. We're now going to clause 24. Those voting in favor of clause 24, can you please raise your hand?
Thank you, Chairperson. Honorable Mashodi in favor.
Thank you, Honorable Mashodi.
So, Chair, those members in favour is Honourable Mashodi, we've got yourself, Honourable Duduvu, Honourable Dango, and Honourable Moimang. Those members who have voted against is Honourable Proudaseth and Honourable Boshoff, and no recorded abstentions.
Thank you very much. Can we please lower our hands? Okay. We go now to clause 25. Those in favor of clause 25, can we please raise our hands?
Mashodi in favor, Honorable Chairperson, thank you.
So, Chairperson, those members in favour, we've got Honourable Mashodi, we've got yourself, Honourable Duduvu, Honourable Dango, and Honourable Moimang. For those members against, we've got Honourable Boshoff and Honourable Proudaseth, and no recorded abstentions.
Yeah. Can we please lower our hands? Also getting slower and lower in my hand. Okay, we're now going to clause 26. Those voting in favor of clause 26. Can we please raise our hands?
Mashodi in favor, Honorable Chairperson, thank you.
Thank you so much.
So, Chair, those members in favour, we've got Honourable Mashodi, we've got Honourable Duduvu, Honourable Dango, Honourable Moimang, and yourself. And those members against, we've got Honourable Boshoff and Honourable Proudaseth, and no recorded abstentions.
Okay. Can we please lower our hands? Thank you so much. We're now going to clause 27. Those in favor of clause 27, can you please raise your hand?
Moshodi in favor, Honorable Chairperson. Thank you.
Thank you so much.
So, Chair, those members in favor, we've got Honorable Mashodi, we've got yourself, Honorable Duduvo, Honorable Dango, and Honorable Moimang. Against, we've got Honorable Boshoff and Honorable Prataseth, and no recorded abstentions.
So much. Can we please lower our hands? Honorable Duduvo. Okay. We're now going to clause 28. Those in favor of clause 28, can you please raise your hands?
Honorable Moshodi in favor, Chair. Thank you.
Thank you so much.
So, Chair, those members in favor is Honorable Mashodi, Honorable Duduvo, Honorable Dango, Honorable Moimang, and yourself. And those members who have voted against is Honorable Boshoff and Honorable Prataseth, and no recorded abstentions.
Okay. Thank you so much. Can we please lower our hands? Okay. We're now going to clause 29. Those voting in favor of clause 29, can you please raise your hand?
Honorable Moshodi in favor, Honorable Chairperson. Thank you.
Thank you so much.
So, Chair, those members who have voted in favor is Honorable Mashodi, Honorable Duduvo, Honorable yourself, Honorable Moimang, and Honorable Dango. Those members who have voted against is Honorable Boshoff and Honorable Prataseth, and no recorded abstentions.
Thank you so much. Then we go, can we please lower our hands before we go to the next clause? Okay. Those in favor of clause 31, can you please raise your hand?
Sorry, Chair, clause 30.
Oh,
we just did 29. You missed 30.
Well, maybe I ticked 30 before I. Okay, sorry for that. Can we then raise our hands, those who are voting in favor of clause 20? Is it 30?
No, it's
30.
30.
Oh, okay, sorry. Those who are voting in favor of clause 30, can you please raise your hand?
Moshodi in favor, Honorable Chairperson. Thank you.
Thank you so much.
So, Chair, those members in favor is Honorable Duduvo, Honorable Dango, Honorable Moimang, and yourself. And those members who have voted against is Honorable Boshoff and Honorable Prataseth, and no recorded abstentions.
Thank you very much. Can we please lower our hands? Okay. So now we're going to clause 31. Is it correct?
Yes, Chair, correct.
Let me check after I've double checked. Those in favor, can we please raise your hand?
Honorable Moshodi in favor, Chair. Thank you.
Thank you so much.
So, Chair, those members in favor, it's yourself, Honorable Mashodi, Honorable Duduvo, Honorable Dango, and Honorable Moimang. Those members who have voted against is Honorable Boshoff and Honorable Prataseth, and no recorded abstentions.
Thank you so much. Can we please lower our hands? So we now go to clause 32. Those voting in favor of clause 32, can you please raise your hand?
Moshodi in favor, Honorable Chair. Thank you.
Thank you so much.
So, Chair, those members in favor is Honorable Duduvo, Honorable Dango, Honorable Moimang. We've got yourself, and we've got Honorable Mashodi. Those members who have voted against is Honorable Boshoff and Honorable Prataseth, and no recorded abstentions.
Okay. Can we please lower our hands? Thank you. We now go to clause 33 on page 14. Those who voting in favor of clause 33, can you please raise your hand?
Honorable Moshodi in favor, Honorable Chairperson. Thank you.
Thank you so much.
So, Chair, those members in favour is Honourable Mashodi, we've got Honourable Duduvo, we've got Honourable Dango, we've got Honourable Moimang, and we've got yourself. Those members who have voted against is Honourable Bashop and Honourable Bradeseth, and no recorded abstentions.
Thank you so much. Can you please lower our hand? Thank you so much. We're now going to close 34. Those in favor, please raise your hands.
Mashodi in favor, Honorable Chair. Thank you.
Thank you so much.
So, Chair, those members in favour is Honourable Mashodi, Honourable Dango, we've got yourself, we've got Honourable Moimang and Honourable Duduvo. Those members who have voted against, we've got Honourable Bashop and Honourable Bradeseth, and no recorded abstentions.
Thank you so much. Can you please lower our hands? Okay. We're now going to close 35. Those in favor of close 35, can you please raise your hand?
Mashodi in favor, Honorable Chairperson. Thank you.
Thank you so much.
So, Chair, those members who have voted in favour, we've got Honourable Dango, Honourable Duduvo, Honourable Mashodi, Honourable Moimang, and we've got yourself. Those members who have voted against is Honourable Bashop and Honourable Bradeseth, and no recorded abstentions.
Thank you so much. Can we please lower our hands? Honorable Moimang, please let's lower our heads. Thank you so much. And we now go to clause 36. Those voting in favor of clause 36, can you please raise your hand?
Mashodi in favor, Honorable Chairperson. Thank you.
Thank you very much.
So, Chair, those members who have voted in favour is Honourable Mashodi, Honourable Dango, Honourable Duduvo, we've got yourself, we've got Honourable Moimang, and those members who have voted against is Honourable Bashop and Honourable Bradeseth, and no recorded abstentions.
Okay. Can we please lower our hands? We're now going to clause 37 on page 15. Those in favor of clause 37, can you please raise your hand? If you're voting
Mashodi
in favor.
Mashodi in favor, Honorable Chairperson. Thank you.
Thank you so much.
So, Chair, those members in favour is yourself, Honourable Mashodi, Honourable Dango, Honourable Duduvo, and Honourable Moimang. Those members against is Honourable Bashop and Honourable Bradeseth, and no recorded abstentions.
Thank you so much. Can we please lower our hands? Thank you. Now going to clause 38. Those voting in favor of clause 38, please raise your hands.
Mashodi in favor, Honorable Chairperson. Thank you.
Thank you so much. Ms. Madia.
Yes, Chair, those members in favour is Honourable Duduvo, Honourable Dango, we've got yourself, we've got Honourable Moimang.
I don't put my hand up. Oh, sorry. Good afternoon, Chair. Sorry, I'm trying to find the hand, but I can't seem to put my hand up.
You wanted to say something?
Yes, I wanted to interject with regard to clause 39. One of the submissions was with regard to the in line 51, where it says at least 30, it has 30 in brackets and 60 underlined. That 30 was not in the Principal Act, so that 30 in the bracket should be omitted and the 60 should not be underlined. That's a technical correction, Chair.
So it was in so I was saying must insert 60 because the underline means must insert.
No, we're saying the deletion should be the open bracket 30
yes.
And close bracket, that should be omitted. And then 60, the underlining of 60 should also be omitted. So it should just read
provided that at least 60 days without any underlining or brackets.
Oh, okay. Isn't it that 60 is not an amendment, a new amendment? Is that what you're
Yes,
saying?
Yes, Chair.
Oh, okay. No, thank you for addressing that.
Thanks. Chair, and I'll come in at clause 43 again. Thanks.
Or you'll come in at clause 43 again.
Yes, thank you,
I
Chair.
think let's also allow the legal advisor from Parliament, if there are any other clauses that you want to also advise us on, you can do that as well. Ms. Williams? Oh, Ms. Isaac, so am I correct?
No, I think that's the chief law advisor, Ms. Williams.
Yes, I know that one, sorry,
Yeah.
but I'm also indicating if Ms. Isaac can do the same as well, if there is any clause that she was to bring to our attention. Yeah, if she can do that. Oh, sorry, it's Mr. Mjenxane, because it's a COIDA. Yeah, no, Mr. Mjenxane, if there is any clause that you want to bring to our attention as well, you can do so as well. So, Mr. Mjenxane.
No, Chairperson, I've noted what you said, Chair. Thank you. We have discussed with my colleague from the State Law Advisor, and I've agreed that she will attend to these issues that she has raised. We've agreed on them, Chair. Thank you.
Oh, okay. So, honorable members, then we're going to vote on clause 39, but you take into account that that 60 must take out the underline, so it's not a new amendment. Yeah. Thank you.
Just for the record, sorry, we were still busy with voting on clause 38. We hadn't moved it. Yeah, we didn't move yet to clause 39.
Oh yeah. Have we voted for 38 yet?
Members were still, members were in the process of voting.
Oh, okay. Or maybe let's lower our hands and then start from afresh so that we don't get confused. Can we lower our hands? Honorable Dodov, can you please lower your hand? Honorable Moima, can you also lower your hand? We're starting afresh on clause 39. Yeah.
38.
38, sorry. Those voting in favor of clause 38, can you please raise your hand?
Mushodi in favor, Honorable Chairperson. Thank you.
Thank you so much.
So, Chair, those members in favor of clause 38 is honorable, as we've got yourself, Honorable Mushodi, Honorable Dango, Honorable Moimang, Honorable Duduvo, and those members who have voted against is Honorable Bashak and Honorable Brabdusef, and no recorded abstentions.
Thank you so much. Can we please now lower our hands?
Chairperson, can we take a 5-minute break?
5 minutes. Okay, let's just deal with this one, 39, and then we'll take a 5 minutes break. You know, we're still going to do the same with the employment equity. So we will be having
and it's quite critical because I think we need to manage in such a way because 6:30 my transport will be taking up to Parliament. Thank you. And the reception along the way, I realized yesterday that it has some challenges.
Oh,
thank you.
Okay. No, that's fine. That's fine. As long as we'll have the quorum and the majority of votes. Yeah. Can we go to 39, but taking into account the advice that this section 39 will be without the 60 that is underlined, so it's not an amendment, so it's not an insertion. That's 60 days. The 30, you said 30 is it's omitted.
Yes, Chair.
Yes, 30 is omitted, but then 60 is not a new insertion.
Yes, it won't be underlined.
It won't
so
be
it will read, provided that at least 60 days before any such amendment, a notice shall be published in the Gazette. Yeah.
Okay, thank you so much.
Thanks.
I take it that the hands are voting in favor of clause 39?
Yes,
Isn't
Chair.
it?
Correct,
Okay.
Chairperson.
Correct, okay.
Honorable Mushori must be included, Honorable Chairperson. I vote in favor.
Thank you so much.
Okay, so Chair, taking into account the issues that were just raised by the Chief State Law Advisor, those members who have voted in favor is yourself, Honorable Mashodi, Honorable Duduvo, Honorable Dango, and Honorable Moimang. Those members who have voted against is Honorable Boshoff and Honorable Proudaseth, and no recorded abstentions.
Thank you so much. Honorable Dango, can we just finish this next page, page 16, because it also got clause 43, which will be advised on as well.
No problem.
Right. Thank you so much. Can we lower our hands, please? Honorable Todov, can we please lower our hand? Thank you so much. We're now going to clause 40 on page 16. Those voting in favor of clause 40, can you please raise your hand?
Mushori in favor, Chair. Thank you.
Thank you so much.
So members, so Chair, those members who have voted in favor is Honorable Mashodi, we've got yourself, we've got Honorable Moimang, Honorable Duduvo, and Honorable Dango. Those members who have voted against, clause 40 is Honorable Boshoff and Honorable Proudaseth, and no recorded abstentions.
Thank you so much. Can we please lower our hands? Thank you so much. We're now going to clause 41. Those in favor of clause 41, can you please raise your hand?
Mushori in favor, Chair. Thank you.
So much.
So Chief, those who have voted in favor of clause 41 is Honorable Duduvo, Honorable Moimang, Honorable Dango, we've got yourself and Honorable Mashodi. Those members who have voted against is Honorable Boshoff and Honorable Proudaseth, and no recorded abstentions.
Thank you. Can we now go to, can we lower our hands first? Thank you. And we're now going to clause 42. Those in favor of clause 42, can you please raise your hand?
Mushori in favor, Honorable Chairperson. Thank you.
Thank you so much.
So Chair, those members who have voted in favor of clause 42, it's Honorable Dango, Honorable Duduvo, Honorable Moimang. We've got yourself and we've got Honorable Mashodi, and those members who have voted against is Honorable Boshoff and Honorable Proudaseth, and no recorded abstentions.
Okay. Can we now please lower our hands? Can you come in now, Soraya?
Thank you, Chair. Chair, in clause 43, line 52, it's just a consequential amendment due to the lapse of time. So we're proposing that since we are doing the other amendment, we might as well substitute 2021 with 2022. Thanks, Chair.
Sorry, can you read it out? Because
okay, it's
can you
clause
please read it out?
43.
Yeah.
Line 52. To substitute 2021 in line 52 with 2022.
Oh, okay, I see that. I see that. Yes. Okay. Do you see that, honorable members? Oh, maybe can you make this slide bigger? Are you able to do that, Madi? In fact, it's the last line, honorable members.
No, we have seen it, Chair.
Oh, you've seen it. Okay.
Yes.
Okay. And can we then, those who are in favor of clause 43, section 73, with this subsection, who are in favor of clause 43 raise their hands?
Moshodi in favor, Chair. Thank you.
Thank you so much.
So, Chief, those members who are in favor of clause 43 with the accepted amendment is Honorable Dango, Honorable Duduvo, Honorable Moimang. We've got yourself and Honorable Moshodi. Those members who are against is Honorable Boshoff and Honorable Brauterset, and no recorded abstentions.
Okay. No, there was a request from Honorable Dango for a 5 minutes break. We still have up to clause 64. We are at clause 43.
44, Chief.
We've just finished clause 43. I was just checking we're still going to clause 64, which will be the last clause of this bill. So can I get an indication whether we should take a 5 minutes break? Honorable Moima?
We can carry on, Chairperson.
Can we?
Oh, thank you, Honorable Dango.
Thank you so much. Can we then lower our hands, including mine? Okay. And we now go to clause 44. Those voting in favor of clause 44, can you please raise your hands?
Moshodi in favor, Honorable Chair. Thank you.
Thank you very much. Ms. Matia.
Sorry, Chair. Sorry, I accidentally muted myself.
I thought you were taking a 5 minutes break.
I might need to, Chair. Latest calling, Chair. I might need to. Those members who have voted in favor, we've got Honorable Moshodi, we've got Honorable Moimang, Honorable Duduvo, and we've got yourself. I don't see Honorable Dango.
Is Honorable Dango still in the meeting? Is Honorable Dango still in the meeting?
Yes, he's still in the meeting, yes.
Okay. Honorable Dango?
My hand raised.
Okay.
All right. Ms. Bhatia, you were still talking?
Yes, Chair. Mr. Dango, your raised hand is not reflected.
Must I raise it again?
Yes. Okay, so in terms of clause 44, those members who have voted for the approval of that clause, we've got Honorable Moimang, Honorable Duduvo, we've got yourself, Chair, Honorable Dango, and Honorable Moshodi. Those members who have voted against is Honorable Boshoff and Honorable Brauterset, and no recorded abstentions.
Okay. Can we lower our hands before we go to clause 45? Okay. We're now on clause 45. Those voting in favor of clause 45, can you please raise your hand?
Moshodi in favor, Honorable Chairperson. Thank you.
Thank you so much.
So, Chair, those members who have voted in favor of clause 45 is Honorable Duduvo, Honorable Dango, Honorable Moimang. We've got yourself and Honorable Moshodi. Those members who have voted against is Honorable Boshoff and Honorable Brauterset, and no recorded abstentions.
Thank you so much. Can we then lower our hands, please? Thank you so much. We're now on clause 46. Those in favor of clause 46, can you please raise your hands?
Moshodi in favor, Honorable Chairperson. Thank you.
Thank you so much.
Chair, those members who have voted in favor, we've got Honorable Dango, Honorable Duduvo, we've got yourself, Honorable Moimang, and Honorable Moshodi. Those members who have voted against clause 46 is Honorable Boshoff and Honorable Brauterset, and no recorded abstentions.
Thank you so much. Can we now lower our hands? Thank you so much. We're now going to clause 47. Those in favor of clause 47, can you please raise your hands?
Moshodi in favor, Chair. Thank you.
Thank you so much.
So, Chair, those members who have voted in favour of clause 47, we've got Honourable Duduvo, Honourable Moimang, we've got yourself, Honourable Mashodi, and Honourable Dango. Those members who have voted against is Honourable Boshoff and Honourable Prataseth, and no recorded abstentions.
Thank you so much. Can we please lower our heads? Honourable Duduvo, can you please lower your hand? Thank you so much. We're now going to clause 48. Am I correct?
Correct, Chair.
Okay. Those in favor of clause 48, please raise your hand.
Moshodi in favor, Chair. Thank you.
Thank you so much.
So, Chair, those members who have voted in favour of clause 48 is Honourable Duduvo, Honourable Dango, we've got yourself, Honourable Mashodi, and Honourable Moimang. Those members who have voted against is Honourable Boshoff and Honourable Prataseth, and no recorded abstentions.
Okay. Can we lower our hands? Thank you. And we're now going to clause 49 on page 18. Those voting in favor of clause 49, can you please raise your hand?
Moshodi in favor, Chair. Thank you.
Thank you so much.
Chair, those members who have voted in favour of clause 49 is Honourable Mashodi, Honourable Moimang, we've got yourself, Honourable Duduvo, and Honourable Dango. Those members who have voted against clause 49 is Honourable Boshoff and Honourable Prataseth, and no recorded abstentions.
Thank you so much. Can we please lower our hands? We're now going to clause 50. Those in favor of clause 50, can you please raise your hand?
Moshodi in favor, Chair. Thank you.
Thank you so much.
Chair, those members who have voted in favour of clause 50 is Honourable Mashodi, Honourable Moimang, we've got yourself, Honourable Duduvo, and Honourable Dango. Those members who have registered voted against is Honourable Boshoff and Honourable Prataseth, and no recorded abstentions.
Thank you so much. Can we please lower our hands? Thank you so much. We go now to clause 51. Those in favor of clause 51, can you please raise your hand?
Moshodi in favor, Chair. Thank you.
Thank you so much.
So, Chair, those members who have voted in favour, it's Honourable Mashodi, Honourable Dango, Honourable Moimang, Honourable Duduvo, and yourself. Those members who have voted against clause 51 is Honourable Boshoff and Honourable Prataseth, and no recorded abstentions.
Thank you so much. Can we now lower our hands? Honorable Moimang, can you please lower your hand? Honorable Moimang? Thank you so much. We're now going to clause 52 on page 19. Those in favor of clause 52, can you please raise your hand?
Moshodi in favor, Chair. Thank you.
Thank you so much.
Chair,
Yes.
are you voting, Chair?
Oh, sorry. I'm looking at the bill now. The next, I'm reading the next clauses. Sorry. Yeah, it's a long.
Yeah, it's a long day. So, Chair, those members who have voted in favour, it's yourself, Honourable Mashudi, Honourable Duduvu, Honourable Moimang, and Honourable Dango. Those members who have voted against Clause 52 is Honourable Bashov and Honourable Prataseth, and no recorded abstentions.
Thank you so much. Can we now please lower our hands? Thank you so much. The next clause is clause 53. Those in favor of clause 53, can you please raise your hand?
Honorable majority in favor, Honorable Chairperson, thank you.
Thank you so much.
So, Chair, those members who have voted in favour of clause 53 is Honourable Mashudi, Honourable Dango, yourself, Honourable Duduvu, and Honourable Moimang. Those members who have voted against is Honourable Bashov and Honourable Prataseth, and no recorded abstentions.
Thank you so much. Can we please lower our hands? Let's go now to clause 54. Those in favor of clause 54, can you please raise your hand?
Honorable majority in favor, Chair.
Thank you so much.
So, Chair, those members who have voted in favour, it's Honourable Mashodi, Honourable Duduvu, Honourable Dango, Honourable Moimang, and yourself. Those members who have voted against clause 54 is Honourable Bashov and Honourable Prataseth, and no recorded abstentions.
Can we now lower our hands, please? Okay, now we are on clause 55 on page 20. Those in favor of clause 55, can you please raise your hands?
Majority in favor, Chair, thank you.
Thank you so much.
Chair?
Sorry.
Okay. So, Chair, those members who have voted in favour of clause 55 is yourself, Honourable Mashodi, Honourable Moimang, Honourable Duduvu, and Honourable Dango. Those members who have voted against is Honourable Bashov and Honourable Prataseth, and no recorded abstentions.
Okay, can we lower our hands, please? And now we're going to clause 56. Those in favor, can you please raise your hand?
In favor, Chair, Honorable Mashodi, thank you.
Thank you so much.
Chair, those members who have voted in favour is yourself, Honourable Mashodi, Honourable Dango, Honourable Moimang, and Honourable Duduvu. Those members who have voted against is Honourable Bashov and Honourable Prataseth, and no recorded abstentions.
Thank you so much. Can we lower our hands, please? Thank you so much. We're now going to clause 57 on page 21. Those in favor of clause 57, can you please raise your hands?
In favor, Chair, Honorable Mashodi, thank you.
Thank you so much.
So, Chair, those members who have voted in favour of clause 57, it's Honourable Dango, it's yourself, Honourable Moimang, Honourable Mashodi, and Honourable Duduvu. Those members who have voted against is Honourable Bashov and Honourable Prataseth, and no recorded abstentions.
Thank you so much. Can we please lower our hands? Thank you so much. We're now going to clause 58. Those in favor of clause 58, can you please raise your hands?
Honorable Mashodi in favor, Chair, thank you.
Thank you so much.
Chair, those members who have registered, who have voted in favour of clause 58 is Honourable Duduvu, Honourable Dango, yourself, Honourable Moimang, and Honourable Mashodi. Those members who have voted against clause 58 is Honourable Bashov and Honourable Prataseth, and no recorded abstentions.
we please lower our hands? Clause 59, those in favor of clause 59?
Thank you, Chair. Honorable Mashodi in favor.
Thank you very much.
So, Chair, those members who have voted in favor of clause 59 is Honorable Dango, Honorable Moimang, Honorable Duduvo, Honorable Mashodi, and yourself. Those members who have voted against clause 59 is Honorable Boshoff and Honorable Radoseth, and no recorded abstentions.
Thank you so much. We're now going to clause 60 on page 23. Can you first lower our hands? Sorry. Okay. Clause 60 on page 23. Those in favor of clause 60, can you please raise your hand?
Mashodi in favor, Chair. Thank you.
Thank you so much.
So, Chair, those members who have voted in favor is Honorable Mashodi, Honorable Duduvo, yourself, Honorable Moimang, and Honorable Dango. Those members who have voted against clause 60 is Honorable Boshoff and Honorable Radoseth, and no recorded abstentions.
Thank you so much. Can we please lower our hand? Now going to clause 61. Can we please raise our hands, those in favor of clause 61?
Mashodi in favor, Chair. Thank you.
Thank you so much.
So, Chair, those members who have voted in favor, I don't know if there's a delay in Mr. Duduvo's hand, but we've got Honorable Mashodi, we've got yourself, Honorable Moimang, we've got Honorable Duduvo, and we've got Honorable Dango. Those members who have voted in against clause 61 is Honorable Boshoff and Honorable Radoseth, and no recorded abstentions.
Can we now lower our hands? Now going to clause 62. Those in favor of clause 62, can you please raise your hands?
Mashodi in favor, Chair. Thank you.
Thank you so much.
Chair, those members who have voted in favor of clause 62, it's Honorable Mashodi, yourself, Honorable Moimang, Honorable Dango, and Honorable Duduvo. Those members who have voted against clause 62 is Honorable Boshoff and Honorable Radoseth, and no recorded abstentions.
Thank you so much. Can we now please lower our hands? We're now going to clause 63. Those in favor of clause 63, can you raise your hands?
Excuse me, Chair.
Support. Yes,
Chair?
Ryan. Yes, ma'am.
Sorry, I don't have the hand function, so I have to interject like this.
No
Apologies
problem.
for that.
No problem.
Chair,
Yeah,
the
just before that, can you ask members to lower their hands?
Don't stress, you are my friend.
Okay, you can come in, Soraya.
Thanks, Chair. Chair, the same with regard to clause 63 as well as clause 64. In clause 63, in line 28,
Yes.
the reference to 2021
Should be 2022.
would be 2022.
Okay.
Yeah, just for the purposes of completion, Chair, I suggest we include that amendment as well.
Okay.
And then similarly, the same would be when before the committee votes on clause 64 in line 35.
Yes.
Sorry, in line 34. The
Okay.
reference to 2021 to be substituted with 2022.
Okay.
Thanks, Chair.
Thanks. We are on 63 now, members. Is that correct?
Correct, Chair.
Okay. Those in favor of clause 63, voting in favor, please raise your hand.
Mashodi in favor, Honorable Chairperson. Thank you.
Thank you so much. That takes into account also that change, which is 2021, compensation for occupational injuries and diseases amendment Act 2021. Okay, Ms. Matia, the results.
Chair, those members who have voted in favour of clause 63 with that amendment is Honourable Mashodi, Honourable Moimang, Honourable Dango, yourself, Honourable Tuduvu. Those members who have voted against is Honourable Boshoff and Honourable Brautiseth, and no recorded abstentions.
Thank you so much. Can we please lower our hands? Mr. China Durovu, can you please lower your hand? Mr. Durovu, can you please lower your hand? Okay, thank you. Clause 64. Those in favor of clause 64, can you please raise your hand?
Mushodi in favor, Honorable Chairperson, thank you.
Okay.
So, Chair, those members who have voted in favour of clause 64 with that amendment, as mentioned earlier by the Chief State Law Advisor, it's Honourable Mashodi, yourself, Honourable Tuduvu, Honourable Moimang, and Honourable Dango. Those members who have voted against clause 54 is Honourable Boshoff and Honourable Brautiseth, and no recorded abstentions.
Thank you so much. Can we please lower our hands? Mr. Mjenxane, what is the next process? Samara, Suraya, on this bill? We're done with the clauses. Can we get advice on the next process?
Chairperson, I think the Parliamentary Law Advisor and the Committee Secretary will be best placed to advise on the procedure because it's a Section 75 bill. Thanks.
Yeah.
I'll hand over to the Parliamentary Law Advisor.
Mr. Mjenxane. Is Samara in?
Can we just check here?
Mr. Mjenxane or?
No, she is still in, Chair.
They might be on the platform, but not in.
Hello, Chairperson.
What is the next process? We've done with the clauses.
I'm sorry, Chair. Sorry, I was just trying to connect here. I'm having some connection difficulties. No, Chair, because this is a 75, if the committee makes amendments, Chair, it must go back to the National Assembly.
Okay. No. I mean, in terms of the bill itself, are we done now with this bill? Because we voted clause by clause.
Yes, Chair. So the next step, Chair, would be the report of the committee on the bill, indicating the process that took place here, Chair. And then the report of the committee will then go to the House to be debated, Chair.
Okay. So we don't deal with the memorandum on the objects of the compensation for occupational injuries and diseases.
No,
so
Chairperson, usually we as the technical staff, we will just align whatever changes may have been made, Chair, to just also reflect on the memo, Chair.
Okay, no, that's fine. No, thank you so much. Can I just check those changes with regard to the year 2021 to 2022? Are those regarded as amendments that must then go to the National Assembly?
Chair, there are usually cosmetic changes, those changes that are consequential and do not necessarily have to be adopted anew.
Okay. No, that's fine. Thanks for the advice. Honorable members, I'll be guided by yourself I think we're done with the compensation for occupational injuries and diseases amendment bill. All that we'll be waiting for will be the report that will be considered in the meeting of the 22nd. Now, the next issue that we must deal with, or the next bill, is the employment equity bill. I need guidance from yourself because there were members that were indicating challenges of transport back to the villages. Just want to know how many will be affected and check if we'll still have a quorum. If some of the members log out. Honorable Mamanga, are you still available?
Yes, my transport is waiting for me outside. I'm going back to Parliament for the JCI meeting. But I'll be on until I arrive there.
Yes.
Yes.
But
perhaps maybe what you get a sense from Nati and Shamara, whether look the process that you followed clause by clause, is it parliamentary? Is there no holistic approach that you could take so that at least we are able to accommodate some of the challenges that we have, mindful of the fact that our work is affected by the commitment that we usually have on this day from 10 until very late. Thank you, Chair.
Yeah, and in terms of on this book on the committee practice, procedures and practice and system, I don't know, it was given to us during the induction. I don't know if you can see it. It states the processes, generic processing of legislation. It says the bill introduced and referred to the relevant committee. That's first stage. And then committee receives a briefing by the relevant government department. Committee facilitate public involvement. We've done this at 3 stages. The next stage says committee deliberate on the public inputs received, which we did, the one that we were starting with. The department respond to issues raised by the public and questions from members, which we've done. Committee proceeds through the bill clause by clause. Amendment, it's written very, amendments. The print is say amendments to the clause are put for yes, I put for decision. Committee adopts a report. Report is published. House consider the report. So those are the processes that are. So this clause by clause, we have to do it, unfortunately, honorable member. So that's why I was checking then if we need to get an indication. I see there's a hand of Mr. Mkalipi.
Chair, yes, Chair, I'm sorry to disturb, Chair. I've just raised it with Mr. Mjenxane that there's a small problem in clause 63. Clause 63 refers to workers when the whole bill and the act talk to employees. Maybe the committee need to consider making also that change so that it refers to employees, not workers. So it's not 63. To create confusion. 63.
On the compensation. Okay. Can you come in, Mr. Mjenxane?
Yes, Mr. Mkalipi has just raised the matter, Chair, and I just wanted to advise that in terms of the procedure, Chair, this is going to lead to a committee amendment. So we just have to formalize it in an amendment, which will then mean that the bill after adoption must then be taken to the NA for consideration. The fortunate thing, Chair, is that because this is just a consequential amendment to align the Act, there is very little possibility of it being rejected or the process of mediation coming into operation when it is referred to the National Assembly. So I just wanted to raise that point, Chair. Thank you.
Can you read the specific clause that need to be changed? Is it this one that says domestic workers and employers?
Yes,
Chair.
Yes,
That
Chair.
one. So how should it read? Domestic employees?
Yes, Chair.
Okay. You know, this can we just check then with this technical? Remember when we were discussing the employment equity, there was a section, I think section 42A, that was not part of the original bill submitted to Parliament. And then there was a discussion whether we could consider that because the bill was advertised without that particular clause. So how do we deal with this one? Can you come in, Mr. Mkalip, on this one, and then Mr. Mjenxane and can come in. So I don't know if Shamara is in. Can you clarify that aspect, Mr. Mkalip, in relation to that section 42A in the bill, vis-a-vis this one?
Well, Chair, understand the issues. Maybe Parliament is better placed to talk to that. This is another technical issue when the whole bill talk to employees and one section talk to workers, because there's a big difference between employees and workers. Workers will refer to people who are not necessarily employees, and that's the issue. That and in terms of one law, the only law that applies to both employees and workers is the National Minimum Wage Bill. All other legislation talk to employees, and even in this one, in all section, it talks to employees.
Yeah, no, I do understand, but my concern is whether something that was not in the original bill, can the committee amend it? Yeah, I just wanted clarity on that. Mr. Mjenxane, can you help us on that part here?
Yes, Chairperson. Chair, this amendment, in my view, but Shamira will also assist as she is much more knowledgeable around the issue of the procedure than I am. But I just wanted to say, Chairperson, that the instance where the committee must seek the permission of the House to make an amendment is where the committee must inquire into a matter in the Principal Act, which was not part of the original bill as introduced. Okay. However, here, Chair, I don't think, in my view, that the committee is dealing with a matter such as that, because here we are not really changing the principle, but you are aligning the wording of the legislation to be consistent, so that it refers to employees instead of workers. So it appears to me as a technical amendment, Chairperson, than an amendment that is changing meaning.
Okay. Shamara, can you assist as well before I go to members?
Thank you, Chairperson. Unfortunately, I differ with my learned colleague on this, Chairperson. Like Mr. Mkalip has stated, the word employee and worker has a very distinct and separate definitions. If we have to substitute one with another, we're actually making an amendment to which the NCOP does not have the power to. Just for clarity's sake, this amendment that the department is proposing, is this in the bill currently before us or the Parent Act?
Can you clarify that aspect, Mr. Mkalip, in the Parent Act?
Can Shamila repeat that?
Mr. Mkalip, in the Principal Act.
Can I ask my colleague Harry to deal with that? He's got the Principal Act in front of him. Harry, can you deal with that issue?
I'm going to come back to members just now. Harry, can you come in, please?
Yes, thank you. The word workers is not in the Principal Act. What is in the Principal Act throughout, you will never find any word such as worker. It's only employee or employees. So I think this was inherited from the High Court and the Constitutional Court decision, because we were talking about domestic workers. So I think it was inadvertent on our part to use the word worker instead of employees. But otherwise, if you look at section 1, where the amendment is done for the inclusion of the domestic employees under the Act in order to benefit like any other employee, is under the definition of employee. It says the employee is blah, 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 but does not include, let me check it here because I've got the Act with me, but does not include the domestic, what is it now? Because I have it.
Yeah.
I'm getting, yeah. Just a minute, because yeah, I've got it here now. It's talking about, but does not include a number of people. It does not include a domestic employee. So the Principal Act is talking about, even under the definition in the Principal Act, where the exclusion is talking about a domestic employee, not domestic worker. Yeah, so it's not in the Principal Act.
Okay. The section that indicated those who are excluded by the Act.
Yes, yes.
Can we go back to Shamara with this explanation?
Thank you. My concern is still the difference in definition of the two, Chairperson. Any amendments by the committee would, or any proposed amendments would have to go back to the NA. If this clause is within the Act before the committee, there isn't a problem. But if it's in the Act, not the bill, then we have a problem and we won't be able to agree to that amendment, even if it is a consequential amendment, because procedurally it would be incorrect.
Let me go then to members. I don't know if they've dropped their hands. Mr. Mjenxane, is it all hands? Oh, before that, can we take Honorable Boshoff and Honorable Protestant?
Thank you very much, Honorable Chair. I agree with Shamara. We do not have the powers to bring about any amendments, so it must go back to the NA because it is procedurally incorrect. Thank you very much.
Thank you so much. Honorable Protestant?
I'm in agreement with Honorable Boshoff. It would be improper and irregular for us to act in the way that is being suggested. We have to refer it back.
Okay. I don't know about referring it back, because it's either we amend it or we leave it as it is, as we have voted for it, and for the department to because it's from the portfolio committee with that part which says workers, not employees, unless when it was with the portfolio committee, it said domestic employees. But if in the portfolio committee it said domestic workers, we won't be able to change it here, because when we advertise it, we advertise it with that wording, domestic workers. Where was the problem? Was it, is it only picked up now, or was it picked up in the portfolio committee as well? But if it was picked up, why was it not then changed before it came to the select committee? Soraya, are you raising your hand, or I see you reflected on the screen?
Thank you, Chairperson. I wasn't raising my hand, but I don't know if this may help if I refer the committee to Section 75 of the Constitution, which speaks to what the committee can do is that the National Council may pass the bill or pass a bill subject to amendments proposed by it, or it can reject the bill. So should the committee consider to make this proposed amendments, the committee can propose amendment and then the bill will go back, like my learned colleagues have said earlier on. But the committee has the power to propose the amendment. Thanks, Chair.
Thank you very much. Lawyers are confusing us. They are not saying the same thing. I'll go back to Mjenxane and lastly, Shamara.
No, Chair, I agree with my colleague from the State Advisor's Office.
We can't hear you, Mr. Mjenxane. Can you speak to your mic?
Can you hear me now, Chair?
Yes, very clearly.
Yes, Chair, I was saying that I agree fully with my colleague from the State Law Advisor's Office. The committee is actually amending this legislation now. So, and the committee is not bound by what happened in the portfolio committee. The committee has its own deliberations, own considerations, and makes its own mind about what to include or not include in this bill. That's currently what the committee is doing, as my colleague has read in terms of Section 75. And the choices of the committee are in Section 75(1), where the committee can either pass the bill or pass the bill subject to some amendments if it makes amendments, or reject the bill. So Chair, in relation to the question and point about the terminology that is used there, which is offensive or that is not in line or in sync with the wording in the Act, as I understand it, Chair, that use of the word workers is an oversight, which is technical and doesn't change the meaning of that section. On that, we were raising it such that the committee just applies its mind to that, and that if it is the decision of the committee to then change that, we would just quickly do a quick committee amendment, which would then lead to the removal of the word workers and being replaced with the word employee, which is consistent with the wording in the Act. It does not change the meaning, Chair. But leaving it as it is now might lead to confusion because it is not in sync with the wording that is used in the Act. Thank you.
Okay. Can I check with Shamara the clause that Soraya was referring to in terms of Section 75 of the Constitution? Maybe your interpretation. It says, when the National Assembly passes a bill other than a bill to which the procedure set out in Section 74 or Section 76 applies, the bill must be referred to the National Council of Provinces and dealt with in accordance with the following procedure. A, the council must, 1, pass the bill, 2, pass the bill subject to amendments proposed by it, or 3, reject the bill. So can you interpret that in layman's term for the committee to understand it better?
Chair. Look, I think the proposal made by Nati, which is in concurrence with what the State Law Advisor says, I think it gives us a framework to move forward as a committee. Pass the bill subject to this amendment, which in essence is cosmetic. And therefore it does not fundamentally change. So rejecting the bill or referring the bill back to a National Assembly, I don't think it will be in the letter and spirit of what has been identified now, because clearly it just does. Look, this cosmetic change will not fundamentally alter the thrust of the bill. So we pass the bill subject to the amendment that we are making. Thank you.
Thank you so much. In fact, in the Constitution, there's nothing saying that the bill must be referred to the NB. I just wanted the first members just to go back to, because I wanted Shamara to assist us in interpreting this section 75(1). Yeah.
Honorable Chair.
Yes, Honorable Bosho.
Sorry, could we have an interpretation of 1C as well? Because if you read 1C, it says, if the council rejects the bill or passes it subject to amendments, the assembly must reconsider the bill. I know that Honorable Mjenxane is speaking about cosmetic words and semantics and so forth, but it states clearly in C, subject to amendments, the assembly must consider the bill. So
yes, no, that definitely that is going to happen, but the question whether we have the right to amend or not. So once we agree that we have the right to amend and then we amend, obviously then it will go back to the National Assembly after having it be considered by the House. So that will be the process. But what we want to understand first is 1A, 75(1)(a), 2 in Roman figures. If Shamara can assist us on that part.
Sorry, Chair, sorry,
yes,
if I can just come here. I just want to clarify, the committee can propose amendments. It's not to amend it, the committee can propose amendments.
Okay.
Yeah, so when the committee's report, when the committee sends a report, the committee will propose those amendments and not amend it itself.
So we can't go back to that 63 and amend it now. We can propose it in the report. Is that what you say?
Yes, Chair. If I can maybe also refer the committee to section 68 of the Constitution. In exercising its legislative power, the National Council of Provinces may consider, pass, amend, propose amendments, or to reject any legislation before the council in accordance with this chapter. So in accordance with this chapter, that would go to 75, where the 75(1)(a), as the committee discussed, the committee can pass the bill subject to amendments proposed by the committee.
Okay. So thanks. What I wanted to be clear on is that for now we'll leave as it is in the bill that the clause that we voted, but then in the report we propose the amendment, or we propose it now. We revisit section 53 now in terms of the clause that we voted for, and change it now, the employee, the workers to employee. Or you suggest that then we leave it as it is, as we have voted it, but then propose in the report that we'll be considering next week. In the report that will be considered next week, we open the opportunity to members to make amendments. Is that what you're suggesting, or propose amendments?
Chair, I think the procedural person will be best to advise on this, because it is provided for in the rules of the NCOP, rule 162 sub 4. NCOP rule 162 sub 4. Yeah. The procedural person may be best to advise on that, but when the committee considers this bill, say for example, the committee will pass this bill subject to the amendments. So when the committee passes it now, it will propose amendments. So it will say that they will pass this bill subject to these proposed amendments. So at the same time, when the committee deals with the bill, it will propose the amendments to the bill. So it will pass a bill subject to the proposed amendments. And that amendment would be one such amendment. Thanks, Chair.
Okay.
Chair, it's Shamara. Can I please come in?
Okay.
While you're considering, can we take our 5-minute break?
No, let's just finish this part, Honorable Dam.
Chair.
Yes, you can continue, Shamara.
for clarity and for record purposes, Chair, is it possible that the proposed amendment be flighted so members actually know what is being agreed to and the specific section? Speaking about an amendment in abstract is totally different to seeing it in front of you. If possible, can that section be flighted so members can have a better idea as to the amendment proposed?
Okay. Can you go to clause 63, Madia, of the bill, the occupational, the compensation for occupational injuries and diseases amendment bill? It's just above the short title and commencement. It says 63, one in brackets, domestic workers and employers. So the amendment that is proposed there is that it should say domestic employees instead of workers. So what I wanted to find out is we change it now or we make proposal in the report. And then I was, Suraya suggested that you are in the best position to advise us on that, Shamar, whether we change it now in the bill or we propose it as part of the report.
Chair, for the record, I'm still not satisfied with this proposed amendment. However, if the committee opts to go with the amendment, it can be included in the as a proposed amendment that will be considered by the House. At this point, you can still include it because the House hasn't had sight of the reports or the proposed amendments yet.
But Chair, can I maybe a suggestion? Because I mean it has already been clarified that whether or not it's a consequential amendment or a cosmetic amendment, it's still an amendment. I think for the record, the committee is going to have to vote again on that clause, just so that the report correlates with the minutes of today's session. Because according to the minutes as is already, the committees approved that amendment with 2 members voting against with no amendment. So there has to be a correlation between the minutes and the report.
Yeah, because also there's another legal conundrum whether the committee can review its decision. I think we need clarity on that as well. It's unlike the other clauses that we were made aware before we got to those clauses. But now with this one, we've already taken a decision. Another legal issue is whether we can review the decision that we've taken in the same meeting. Maybe we could also be clarified on that legally by the 3 legal minds. That aspect first before we focus on anything else, whether we are allowed to review the decision we've taken. Suraya, Samara, yes?
Yes, Chairperson, the committee can review its decision.
Okay. Okay, no, that's fine. I don't know if it's all hand, Honorable Boshoff.
Sorry, Chair, yes, it is.
Oh, sorry, okay. Honorable Moima?
Chair, but I think I've been covered by Badia on this matter. That let's take a decision that will be reflected in our report to the council.
So can we then go back to section 4? Sorry, clause 40. I mean clause 63. Sorry. Can you flight it again? Can we then again, those who vote in with this amendment that says domestic employees and employer must report or submit a claim in the prescribed manner with 3 years from the date of the commencement of the Compensation for Occupational Injuries and Diseases Amendment Act of 2022, because we already changed that one, for any accident that had occurred prior the commencement of this act. Those in favor of that amendment, can you please raise your hand?
Mushodi in favor, Honorable Chairperson.
Okay.
Is Dango still on break? 5 minutes break.
Mati, I'll depend on you now. Is Matia? Is she still here?
Sorry, Chi, I muted myself. Sorry, Chi, I muted myself by accident.
Oh,
okay. So those members who have voted in terms of the amendment to Section 63 is yourself, Honorable Mushodi, Honorable Duduvu, Honorable Dango, and Honorable Moimang. Those members who have voted against is Honorable Boshoff and Honorable Prataseth, and no recorded abstentions.
Okay. So in that case, the majority then agree with the amendment, and that will then form part of the report. And then if adopted in the committee, it will go to the House. If adopted in the House, it will then go back to the National Assembly. So that will be the process. Thank you very much. Can we then lower our heads, honorable members? So when Honorable Mr. Mkalipe raised his hand, I was just checking whether we will still have a quorum with regard to consideration of the next bill. So we're getting now to the next bill, the employment equity. Can we flight the bill, particularly the area? I don't have the number, the slide number, but we'll focus on the submission by the stakeholders, engage the stakeholders and the responses of the department. When we're done with those, and then we will then go to the bill and do the same way we dealt with the COIT amendment and vote clause by clause. Can we start with the presentation before the clause by clause? The presentation with the stakeholders' submissions and the department's responses. It's just that I don't know which slide is it. Mr. Mkalip, can you indicate which slide is it? Because I don't want us to deal with the first part that deals with the report itself. I want to go straight to the submissions and the
I don't have the slides in front of me, Chair. Can she move? I'll tell her when she reach there. Just move the slide.
Just continue to move. Move. Continue. Move. I think it's a blue one. The blue one, when we get to the blue, yeah, that one. I don't know if it is blue. I don't know whether it is blue or gray. Yeah. Honorable members, these are the areas that we will be focusing on. So those areas that there were submissions on was section 15, section 16, section 42, section 53, 6. Yeah, those were the areas. And once we're done with those, we will then we will then go to the bill, start with the cover page, the purpose of the bill, clause 1 up to the last clause, the same process. I was asked earlier, instead of reading, I must just call the section, and then members will indicate whether they agree with the submission by a stakeholder or they agree with how the department has clarified that particular area. And then there will be a support for or I don't know whether reserve the position or against, but then it will be clear when we deal with the clause by clause, because the same section will also be in the bill that will be considering clause by clause. But for now, we're considering the submissions and the responses. Can we then start with section 15A? Honorable Moima?
I agree that with the proposal as captured by the department, we agree with its emphasis on differentiation between quotas and EE and EE targets. So we agree with the department's response.
Okay, Honorable Boshoff.
We reserve our opinion. Thank you.
Thank you so much. Any other view? Not. Next slide. Next slide is still on 15A. So we deal with the 15A as a whole. Next slide. Enrico. Section, or still section 50. Okay. You'll guide me, Ms. Isaac and Mr. Mkalip. Can you move on, because this is still 15A?
Yes, Church, this is still the same section.
Yes, yeah, move on. Yeah, move on until we go to sections. Okay, oh, they are not in section 20. Can you move up again? Section 16. Okay. Can you clarify that part, Mr. Mkalip, because it says these are versus section 15A?
Chair, I mean, this is the submission of the from BUSA, where they say that they think that there's a contradiction between section 16 and section 15A, the new section. And that's what we're answering there, that there's no contradiction on these issues that are being raised there. Therefore,
the one that deals with the employment equity targets.
Yes, the section 16 is a section that requires employers to set on their own, what is this, the previous
plans.
section that talks, yes, goals
employment equity plans. Yeah.
Yes, and plans, saying that now, because the minister will be setting target, it will be interfering with that. And now we're explaining what it means in terms of section 15A.
Okay. Honorable Moima.
That chair the point raised by the department is quite categorical in terms of making a distinction between what is proposed in the bill and what BUSA is saying. So therefore, we agree with the posture taken by the department on this matter.
Okay. I don't know if it's Soraya who's I heard somebody saying something. Honorable Boshoff.
We reserve our position. Thank you.
Thank you so much. Any other comments? Okay, can we move to another?
We are happy, Chair.
Thank you so much. Okay.
We believe that this matter was extensively exhausted at the level of that leg where Busa was also represented. And at that level, they also expressed their views in terms of this particular matter. And therefore, we agree with the department.
Thank you so much. Next section. Section 20. Why don't I have section 20? Section 20. Can you also again clarify this one, Mr. Mkalib? The numerical goal set by an employer in terms of subsection 2. What was the submission again?
The submission by the financial intermediary is that we should not set sectoral targets. We should delete the word sectoral targets in that section. That's the only thing that they're asking, and it should just say targets. And that's our response disagreeing to that. That we disagree with just saying target. The targets should be based per sector, so that we able to look at the different sectors of the economy. Their proposal is that Section 15A should not talk to sectoral targets.
Okay. I just want to also check with the legal advice. There was that section that was not previously part of the bill. If we could be also made aware of, so that members can input. I don't know whether it's, I know it's section 42, but I don't know whether it's this particular section. Perhaps let's just focus on section 20 for now. Honorable members, what's your take on section 20?
On section 20, I reserve our opinion.
Okay. Honorable Mjenxane?
We agree with the position that's adopted by the department in explaining and responding to what Thea is saying, Chair. Thank you.
Okay. Mr. Isaac?
Honorable President.
Yes.
Honorable Musodi, Honorable Chairperson, I support Honorable Mjenxane. Thank you. We are happy.
Okay. I don't know if Ms. Isaac, you're going to talk to section 20.
Yes,
okay.
Yes, your permission. I just want to alert the committee that just the wording in section, the proposed clause 6, amendment to section 20, the word sectoral target is not consistent with clause 4, which is the amendment, the proposed 15A. So when we look at the bill, I'll just point out where the inconsistency is so the members can have sight of that and consider whether they want to align the wording.
Oh, okay. So you'll bring that to our attention when we deal with the bill. Thank you so much. You'll also advise us on that section 42A.
Yes, Chairperson, I think it's still coming up in the slide.
Okay. In fact, was on section 42 on the same slide.
Again, we reserve our position.
Okay.
We agree, Chair, with the explanation as given by the department in response to
the submissions. Okay. The next slide.
Thank you.
You're still on section 42A. it is important for targets to take into account. Oh, this is the area, isn't it, Ms. Isaac?
Yes, Chair. Yes, Chair, that's the area.
That is it.
Yes, Chairperson. This issue was raised with the committee at the beginning of this process, and we now have a submission from COSATU who is proposing an amendment to Section 42A of the Act, which is to change the word "and" to "or." Chairperson, our advice previously, and it still is the same, is that the committee is entitled to consider an amendment. This amendment is not in the bill. However, this is an amendment to the Principal Act. Because this particular amendment was not part of the public participation process, then that raises a challenge. In terms of the Constitution, the NCOP and its committees are required to facilitate public participation in its processes. And while this amendment may seem technical in nature, it seems like we're changing an "and" to an "or." Until we advertise this and get the public, to comment, we cannot make that assessment just based on, a single submission. This process has been quite long, and this proposed amendment is coming quite late in the process. So we will have to open up our public participation process to advertise this particular amendment before the committee considers it, and we have to see whether there's comments for or against it and take that into consideration. I will just alert the committee of the case of South African Veterinary Association versus Speaker of the National Assembly, where there was an amendment proposed during the deliberations, during the NA committee, during the NA phase of a bill, where one of the public submitters proposed amendment to a bill that was under consideration. And because the committee had not opened up the public participation process again to consider that particular amendment because it affected a specific group of people, the bill was held to be unconstitutional when it was challenged for that issue alone. So I will just caution the committee, if they want to consider this amendment, then they need to consider reopen the public participation stage of the process before they make up their minds on this particular amendment. Thank you, Chair.
Thank you so much. I think, members, we already took a position with regard to this part, because we were saying that because it was not part of the bill, we were going to only consider what was before us. So it was not a part of the bill at the time. So already we have a decision. It's just that now we could not stop the stakeholders from coming up with their own amendments. But we are mindful of the fact that already we had a position on this, and but also taking into account the fact that if we agree with this section or amendment, they mean the processes that the legal advisor is indicating, it would mean that we must suspend the process and wait for the public involvement processes before we finalize. So at the time we just said we were going to consider what was before us, and what was before us did not include this part of the amendment. Honorable Maimang. I see your hand is up, Honorable Maimang.
Honorable Maimang is not there. I can speak, Chair.
Okay.
I know what COSATU is saying, and I do agree with COSATU, but I want to express a view that says the department is saying it has mistakenly omitted this part that COSATU is raising, because this part was discussed at the level of NETLEG, and there was an agreement at that particular point. My concern is how many of these that the department has mistakenly omitted, because they need to be identified as well. Why did, in the first place, while agreeing my concern is that why did in the first place they omit this important part that COSATU is raising, whilst I fully agree with the fact that this target must be done in terms of geography, given the diversity of our own country. Thank you very much. I agree, but nevertheless, thanks.
Yeah. Well, thanks. So members, then I think we should pass this one, and we stick to our original position with regard to this one. The department may then come up with a new amendment that will take the normal processes of the law, be presented to Parliament and refer to NA portfolio committee, and then come back to the NCOP with all those other processes that involve the public. Because it would mean now, if we were to consider it now, must because it was not part of the bill that was advertised, it will mean that we must now again, if we agree with this clause must then be advertised. And I was advised by the legal that it could take about 100,000 rands just to advertise this particular clause, and then it's another process. It must then come back to the committee where we hear the stakeholders on that particular clause, what they are saying, and then the response of the department on that clause. So it's a very long process that could suspend the processing of this bill. Honorable Tam.
Chairperson, this issue was raised in the Western Cape some years ago, and it had some very, very detrimental consequences. So I think we should just consider very carefully when we're saying we must come back to it, because if the bill goes through as is, there could be consequences in those areas. Thank you.
Thank you so much. So we agree that we don't consider the issue raised by COSATU nor by the department, because the department is agreeing to this, but the challenge for the committee is that it will mean that we could suspend this process. If we agree with that clause, it means now we must start afresh and advertise and invite the stakeholders to come and present. Maybe it would be easier if the department itself brings that clause back as part of the amendment. In fact, that's what we said in the second meeting, that when we were dealing with the Employment Equity Amendment Bill and the COITA. Honorable Moima.
I think my network connectivity is very weak. Maybe I must just register and note my approval in all the sections, so that my approval with the section ST will be recorded, and also voting in favor of all the sections, so that in case there is a challenge, I'm covered on.
I don't know if this one we're talking about, because on this one we are indicating that in the meeting, remember we got a written legal opinion from the legal unit, and also the advice by the procedural unit, and then we decided that because it was not part of the bill, so we could not consider it. We agreed in the meeting that we will consider what was before us.
So that one, I 100% agree with the decision that I agree 100%, Chair, with the decision that we took to say the amendment will invite public, but it cannot be entertained now. Thank you.
Okay. Thank you so much. Honorable Bosho.
Thank you, Chair. I fully agree. Section 42 was brought to us after it was passed by the NA, so I do not think it would be wise to incorporate it. Thank you very much.
Thank you so much. In fact, it was not even part of the NA because there was a mistake that was discovered by the department after it had gone through
That's right.
the NA processes. And then we agreed in the last meeting that we were not going to consider what was not in the bill as per the advice. But now it has come back, but through the submission of the stakeholders. But our position remains because it's going to take us a long time now to adopt it and then advertise again. And yeah, it will be a long process. So can we then go to the next section? Enrico? Section 53.
Chair.
Okay. Honorable Boshoff.
Okay, let the door go, or can I speak?
Oh, you can speak here.
Okay, we again reserve our position. Thank you.
Thank you so much. Honorable Dodo. No. Honorable Tango.
Chair, it was a legacy hand, sorry.
Oh, can you comment on this one, section 53?
Chairperson, I agree with the department's response.
Oh, okay. Thank you so much. The next one, I think it's the last one, if I'm not mistaken. Go down. So it's still part of section 53. Go down. Mr. McCallum, can you advise us on this one? Is it a schedule or is it a section?
It's the financial intermediaries which deal with fines, where they say the levy to non-compliant with other section of the statute should apply to non-compliant with section 58. Therefore, they don't want the fines as stipulated in the Act. They want other fines to be stipulated on this issue. And that's the issue that they are raising.
Which section is it?
They say the fines that are in the Act. Presently, there are two kinds of fines in the Act. Yes. Now, the fines that apply here is those that deal with the turnover. If you don't apply, percentage of your turnover will be affected in this. They don't like that part of the amendment, that the fines. They recommend that the minister consult river sectors on that the fines must be reconsulted. Therefore, they must not be in the Act as they are. That there must be another regime or regulation for the fines that the minister concentrate on. But the issue is that there's no amendment. As you say, if you couldn't deal with the other amendment, you can't deal with this because there's no amendment on the fines. Also, the same principle.
Okay.
Will apply.
No, that's fine. Thank you so much. The next slide. We dealt with section 53.
Yeah,
isn't it?
We dealt with it.
Okay. Next one. Just before that, Enrico, can you go back? Yeah, go back. Yeah, there where you are. No, don't move. Okay. Yeah, the issuing of compliance. Can you talk to this one? Was it part of the amendments?
Chair, I mean, all of these slides that are following, the stakeholders are not questioning the amendment. These are policy issues. First, the fact that they are arguing that a certificate will create corruptions and all those issues that they are raising. And then all of these other amendments is about the view of the members, not on the amendments per se. The view that first issue that the certificate will create opportunities for corruption. And then we're explaining here how would issuing a certificate happen in terms of being in the system, the computer issuing it, not a person issuing a certificate and all those issues. Those are the kind of compliant response that we are giving on the policy issues that were raised, not necessarily the amendment.
Okay, no, that's right. in any case, those were in the form of a template, those where there's a submission and the responses. I think we're done with that one. So now what we're going to do, we're going to go back to the bill. You can take off this one, Enrico, and put up the bill.
And Chair, if they can enlarge the bill because it's not always readable. Yeah.
Okay, I think it's yeah, I think it's fine now. It's readable. Do you want a 5 minutes break, honorable members, or should we continue? Okay, let's continue. I hope we're all here. I hope we're all here. Let me just check. Honorable Dango, can you drop your hand? Because we're going to be also voting now.
Thank you.
Let's start with the cover page. The name of the bill. Also the number of the bill. Can you vote on that? Those in favor, can you raise your hand?
Thank you, Honorable Chairperson. Honorable Mshodi, vote in favor.
Okay. Do we have Madia with us?
Yes, I'm still here, Chair. Chair, we seem to have we've got so far. I know Mr. Duduva just got disconnected and he's just reconnecting now. So far we've got in favor, we've got yourself, we've got Honorable Dango and Honorable Mashodi. I think Mr. Duduva is still busy.
And myself.
Yes.
And myself.
So we've got 4 members in favor, Chair.
Thank you so much. Okay. You'll continue the same way. Can we just establish again if it's the same procedure with regard to Honorable Boshoff and Honorable Tim? Are you taking the same approach that on all of them you're voting against?
Yes, we are. Thank you very much.
Thank you so much. Yes. Okay. Is the size is still fine? Because I think it's been reduced. I don't know whether it's because of it. Is it still fine? Is it readable?
So far, we can read it. We're still on page 1, so that's
Can you make it a bit larger, Chairperson?
Yeah, that's what I see that it got smaller now.
They can still enlarge it, Chair. Okay, but how many votes did you have on the first page?
4. We had 4, but Mr. Moimang just rejoined the platform. So I think he just voted. So now it's 5 with Mr. Moimang. So those members who had voted on the cover page was Honorable Moimang, Honorable Duduvo, Honorable Hai, Honorable Mashodi, and Honorable Dango. And those members who had voted against is Honorable Boshoff and Honorable Brautisef, and no abstentions.
We pardon you because we know you're as tired as we are.
Thank you.
All right. Can we lower our hands, honorable members? Thank you so much. Can we go to the purpose of the bill? Those in favor of the purpose, can you please raise your hand?
Thank you, Chair. Honorable Mashodi in favor.
Thank you so much.
So, Chair, those people, those members who have voted in favour is Honourable Mashodi, Honourable Duduvo, Honourable Moimang, Honourable Dango, yourself, and those members who had voted against is Honourable Boshoff and Honourable Protesef, and no abstentions.
Right. Thank you so much. Ms. Isaac, you'll indicate if there are areas that you want to bring to our attention on the bill.
Yes, I will, Chair.
Okay, thank you so much. Can we go now to clause 1? No, let's first lower our hands. Sorry. Can we lower our hands? Honorable Dodovi and Honorable Dango. Let's lower our hands. Okay. Can we go to clause 1? That deals with section 1. Those in favor of clause 1, can you raise your hands? Honorable Mashodi.
Mashodi in favor, Chair.
Okay. Ms. Madia.
Yes, Chair.
Yeah.
Those members who had voted in favour, it's Honourable Dango, Honourable Moimang, yourself, Honourable Mashodi. I don't know if there's a delay in Honourable Tuduvo's hand being raised because it's not reflecting here on the screen. And then, so that is 4 members currently in favour. And then in terms of members who had voted against is Honourable Boshoff and Honourable Protesef, and no abstentions.
Okay. Let's lower our heads. We now go to clause 2 on page 3. Those in favor of clause 2, can you please raise your hand to support?
Thank you, Chairperson. Honourable Mashodi in support. Thank you.
Thank you so much.
So, Chair, those members who had voted in favour of clause 2 is Honourable Mashodi, Honourable Tuduvo, yourself, Honourable Dango, and Honourable Memang. Those members who had voted against is Honourable Boshoff and Honourable Protesef, and no abstentions.
Thank you so much. Can we lower our hands? Honourable Moimang, can you please lower your hand? Thank you so much. The next clause is clause 3. Those in favor of clause 3, can you please raise your hand?
Mashodi in favor, Honourable Chairperson. Thank you.
Thank you so much.
Chair, those members who had voted in favour of clause 3 is Honourable Mashodi, Honourable Dango, Honourable Moimang, Honourable Duduvo, yourself. Those members who had voted and those members who had voted against is Honourable Boshoff and Honourable Protesef, and no abstentions.
Thank you so much. Let's lower our hand, please. Mr. Dango, Honourable Moimang. Can we now go to clause 4? Am I correct?
Correct, Chair.
Okay. Clause 4, those in favor. Oh, can we lower? Are they voting or are they lower? Can we lower our hands so that I don't get confused before I ask the question? Okay. Those in favor of clause 4, can you please raise your hand?
Thank you, Chair. Mashodi in favor. Thank you.
Thank you so much.
Chair, those members who had voted in favour of clause 4 is Honourable Mashodi, yourself, Honourable Duduvo, Honourable Moimang, and Honourable Dango. Those members who had voted against is Honourable Boshoff and Honourable Protesef, and no abstentions.
Thank you so much. Can we please lower our hands? you so much. And we now go to clause 5. Those in favor of clause 5, can you please raise your hands?
Mushodi in favor, Chairperson. Thank you.
Thank you so much.
Chair, those members who had voted in favor of clause 5 is Honorable Mushodi, yourself, Honorable Dango, Honorable Moimang, Honorable Duduvu. Those members who had voted against clause 5 is Honorable Boshoff and Honorable Brafasef, and no abstentions.
Thank you so much. Can we please lower our hands? The next clause is it's clause 6. Am I correct?
Correct, Chair.
Okay. Those in favor of clause 6, can you please raise your hand? Oh, let's start with Mr. Isaac.
Thank you, Chair. I just would like to point out a technical correction.
Recording in progress.
Occupational levels in the workforce by notice in the Gazette set, and the word is numerical targets for any national economic sector identified in terms of subsection 1. And if we look at the subclause 3, it says a notice issued in terms of subsection 2 may set different numerical targets for different occupational levels, subsectors, and regions within a sector or on the basis of any other relevant factor. So if we scroll down to clause 6, we see it says the numerical, the proposed 2A to section 20 says the numerical goals set by the employer in terms of subsection 2 must comply with the sectoral targets in terms of section 15A that applies to the employer. So it's just the inconsistent wording in 15A.
It should be saying numerical targets,
yes,
not
Chair.
goals. So we should say
not the first one, it's the second one, because it says the numerical goals in subsection 2, that is 22, must comply with any sectoral target in terms of 15A. So the sectoral targets in 15A is what is in on the bill there, and we don't refer to sectoral targets, we refer to numerical targets.
Oh, yes, yes. So we should then delete sectoral and replace it with numerical targets. Is that what you say?
Yes, Chair, that would be a suggestion, but I'm sure the department would also want to comment on that.
Okay, Mr. Mkalipi or Ms. Mamashel?
Ms. Mamashela, can you come in on this?
Thank you, Honorable Chairperson and Mr. Mkalipi. I think, Chair, it's fine to replace it with numerical so that we are consistent with section 15, capital A3. It refers to different numerical targets. We can remove sectoral and put numerical. I wasn't sure earlier. I was thinking we can combine the two, but we need some legal minds to assist us. I initially thought we can say sectoral numerical target so that it's clear that it's sector target, Chair, but we seek legal explanation for that. If we can do both, that will be a bonus, but if we need to replace sectoral with numerical, then that will be fine with us, Chair. I don't know, Mr. Mkalipi, if you agree. Thank you.
I think, Chair, what we need to explain is that this subsection 6, when it says, it put 2A and say the numerical goals set by the employer in terms of subsection 2, it's referring to, my understanding, to section 5020, where the employer is expected by the law not to set targets. The current legislation, it talks to numerical goals. If you go to section 20, it says that the employer must have a plan and the plan must have numerical goals within it. Now, Section 2A refers to that section, section 20. That section has not been amended to refer to sectoral target. It's only the minister that set targets. The employer set for themselves numerical goals. And I think that's why it's written the way it's written, because 2A is 2A in section 20, which section 20 talks to the formation of a plan by the employer. And in that plan, the employer must have clear numerical goals. That's what section 20 presently states. And that's my understanding of what that clause is. Not referring to section 2 as 15A.
Ms. Isaac?
Chairperson, yes, I'm not referring to the numerical goals. That is indeed in section 20 currently. I'm referring to the part that says the numerical goals set by the employer must comply with any sectoral target. And there were quite a few submissions pointing out that the sectoral target is not found, that phrase is not found in 15A. We refer to numerical targets in 15A.
Section 15A.
Yes. So it is possible we could consider sectoral numerical targets because that is the heading, or we could call it numerical targets because that's included already in 15A, but that's up to the committee. With the sectoral numerical targets, we'll have to do a few more amendments to 15A. But if the committee accepts numerical targets, then it's an amendment, proposed amendment to 2A.
I don't know, Esma Kaben, I don't know whether to say Mr. or Miss. It doesn't indicate. Can you comment?
Thanks, Chair.
Okay.
Sisa Makabeni from the State Law Advisor, Chair.
Okay.
For me, Chair, it's an issue of, for me, Chair, it's an issue of interpretation of legislation, Chair. And I think the meaning for me is clear because Section 15.8, Chair, refers to the minister setting numerical targets for sectors of the economy. So those sectors, those numerical targets become sectoral targets, Chair, if you look at it. So it's clear that you're cross-referring to 15A. So there's no confusion what you're talking about. It's clear when you read that section that you're talking about the sectoral targets that the minister would have set in terms of Section 15A. So I'm not sure, I'm not certain that, Chair, there will be any confusion as to the interpretation of what is meant there. Thanks, Chair.
So what do you say that you don't think we should include numerical?
I don't think it's necessary, Chair, because the interpretation of what we're talking about is clear. We're cross-referring to the same section that talks about that, and the only way to read it, if you go back and read Section 15A, is to read sectoral numerical targets that are in the heading of 15A and numerical targets that are all around Section 15A. So there's no other way of reading it, Chair.
We sometimes lawyers can first talk to each other before they come to the committee.
Chair, the other option, which is far better from where I'm sitting, is to substitute in Section 15A all the numerical targets with the sectoral targets. Then it will talk to the, it will solve the same problem that, yes, I understand the input by my colleagues from state law advisors, but the issue that I'm raising, if it's going to create any confusion in the labor market, it might be legal. If it's going to create any confusion, it's far better to make the changes in 15A. Let everywhere where it's talked to numerical targets, to refer to sectoral targets. And then that will be in line with this 6. Because that's what in the public arena we talk about. That's what even at the sectors that we are negotiating with, setting target for them. If we hear there's a confusion here, it might then be worse in the labor market if we don't make that change. I'm not arguing about the legality. I think it's legal, but I think that it's cleaner, better if you take out the numerical target you picked up sectoral target as the intention of this section. If you look at the heading of the section, it says determination of sectoral numeral targets. Therefore, maybe we can follow that route. I don't want to lose the word sectoral because that's the most important word in this. Remember, there was also the argument made by...
Yes, I think we shouldn't confuse numerical goals with targets.
Yeah, now we're getting confused more. So what do we do? Do we change numerical under 15A and replace it with sectoral?
Can I just
So
raise
that there's consistency then in clause 6 sub section 2A. Can I get clarity on that? Sorry, who was talking?
No, it's me, Chair. But I just wanted to say something. Just in terms of the recording, this was a big issue when the committee was receiving submissions in terms of the public hearings. And I think there was also this big issue with regards to targets versus quotas. So I think, sorry, I just lost my point now. But I just think that I just wanted to bring that in, that if the committee is speaking to numerical targets, just to clarify that language so that we can just capture it correctly for the minutes and for the recording.
Yeah, that's what I still want clarity on before we decide whether we agree or we don't agree. First, let's get clarity. What do we actually want to change? Is it numerical or is it sectoral? Honorable Tim? Okay.
Yeah, Chairperson.
Can we wait for Honorable Tim so that you can also, when you comment, take into account his views? Honorable Tim, can you go ahead?
Chairperson, I just wanted to note that I think this is completely unsatisfactory on behalf of the department and the legal advisors. This is something that should have been, why did the department not pick this up at portfolio committee level? This is the third or the fourth mistake that we're finding tonight. While we sit here trying to go through the work, then we're finding, oh, sorry, there was this mistake. Oh, sorry, there was this oversight. And I just think that the committee should note that the department should really be a lot more careful when they are putting together legislation and making sure it's correct. And we have to sit here trying to fix their mistakes out and trying to work out these legal wrangling problems. And Chair, I also get very concerned that we can only push this through as a proposed amendment anyway. So, yeah, I just want to note my dissatisfaction with this, Chair. Thank you.
Thank you. Now, on this one, it's not the department, it's a suggestion by the Parliament legal advisor. I'm sure she was concerned about consistency, that in one area we talk of numerical targets, and then on clause 6, we drop the numerical and talk about sectoral. So she wanted some consistency, whether we're talking about sectoral numerical targets or we talk about numerical targets as section 15A refers to. So she wanted clarity around that. I won't say this time it's a department, but it's a concern that was raised by the legal unit of Parliament. Honorable Dango.
How does it change the meaning? Because the minister was very strong when he was briefing us on the question of targets versus quotas. Does the changing of the word actually have an impact upon the issues of targets and quotas? I just need some clarity on that.
Okay, Honorable Boshoff.
Thank you very much, Chair. There's a big difference between sectoral targets and numerical targets. So my feeling is that if you change it, with Honorable Braathlseth, then it is a proposed amendment and must be referred back. We cannot change one version to that read sectoral to numerical, vice versa. Thank you.
Honorable Memang, and then we'll go to Mr. Mkalip. And then
Chair, in A1 talks to the minister identifying national economic sectors, and 2 talks about numerical targets. But as said, the heading is sectoral numerical targets. So I think the heading should be able to deal with the confusion that is being identified, to say if at this level there is this confusion. Probably the question would be, if we under 2 say set numerical sectoral targets, doesn't that address the confusion? Thanks.
Thank you. Mr. Mkalipi, I think we need to come to a conclusion in this matter. Either we agree with Mr. Makabini that we just drop this issue, as long as we understand that clause 6 would be known that it is referring to clause 4, which deals with section 15A. Mr. Mkalip?
I mean, if the committee want to make any change, for me, the change should go in line with the heading of the section. The heading of the section is determination of sectoral numerical targets. You can easily say then, wherever you talk about targets, you have that wording there that says sectoral numerical targets, because that's what the heading says. And therefore it's easy to make that change and just make that change as a committee, because it's in the heading itself.
Can we leave it at that then? Let's not make changes. Let's leave it at that, and knowing that we're guided by the heading, which says determination of sectoral numerical targets. Everything else falls under that particular heading. Ms. William, sorry, Ms. Isaac.
Chairperson, that is in the discretion of the committee. The committee is comfortable with that wording, and that's fine.
No, I was worried that we don't seem to be having consensus around this issue. And if we're unable to have consensus, we rather just leave it as it is.
Yes, Chairperson, I was just raising the issue because there were 3 submissions on the matter where they pointed out the issue. So in my view, there was a big, because people in the public were raising a bit of confusion on this issue, then I thought it would be something that we could easily clarify as to what we mean, because it's more of a technical to ensure that the meaning is clear. But as my colleague did say, if I as a legal person read it, I do understand what it means. If the committee is comfortable when they read it, that the meaning is consistent, then that is the committee's decision to make.
Okay. I don't know if the hands are old hands. You indicate members if you want to come again.
Chairperson, if the lawyers are confused, I'm a bit afraid. Because this bill and this act, if it goes through, is going to go to court all the time. It's going to be a myriad of continuous court cases. So I think when we go ahead with this particular piece of legislation, we need to be sure from a legal perspective that we're actually going to make it and not invite a whole myriad of court cases down the line.
No, that's why I was suggesting that let's leave it here as it is, because the heading itself clarifies what Section 15A is all about. It is about the determination of sectoral numerical targets. So if we leave it at that, I think it's fine. I don't know if Honorable Tim, it's an all hand or you want to come back again. No, it's an all hand. Okay, can we move then on section or clause 6? Can we vote on clause 6 as it is without any changes? Those in favor, can you please raise your hand? Ms. Madia, are you back?
Yes, Chair. Those members who have voted in favour is Honourable Moimang, Honourable Dango, Honourable Tutuvo, and yourself.
Honourable Mashodi.
And Honourable Mashodi. And those members who have voted against is Honourable Bashop, Honourable Prataseth, and there's no abstentions.
Okay. Thank you so much. Can we lower our hands? Mr. Mkarip, you can switch off your mic. Can we then move to the next clause? Those in favor of clause 7, can you please raise your hand?
In favor, Honourable Chairperson, Honourable Mashodi.
Ms. Madia.
Yes, Chair, those members who have voted in favour of clause 7 is Honourable Mashodi, Honourable Moimang, Honourable Tutuvo, yourself, Honourable Dango. Those members who have voted against clause 7 is Honourable Bashop and Honourable Prataseth, and no abstentions.
Okay. Let's lower our hands, please. Okay, we're now on clause 8. Those in favor of clause 8 on page 4, can you please raise your hand?
Honourable Mashodi in favor, Honourable Chairperson, thank you.
Thank you. Ms. Madia.
Yes, Chair. So the members who have voted in favour of clause 8 is Honourable Mashodi, Honourable Tutuvo, Honourable Dango, Honourable Moimang, and yourself. Those members who have voted against clause 8 is Honourable Bashop, Honourable Prataseth, and no abstentions.
Thank you very much. And we lower our hands, please. Thank you so much. We're now on clause 9. Those in favor of clause 9, can you please raise our hands?
Mashodi in favor, Honourable Chairperson, thank you.
Thank you.
So Chairperson, those members who have voted in favour of clause 9 is Honourable Mashodi, Honourable Tutuvo, Honourable Dango, yourself, Honourable Moimang. Those members who have voted against clause 9 is Honourable Bashop and Honourable Prataseth, and no abstentions.
Thank you so much. Can we please lower the hands? Now go to clause 10. Those in favor of clause 10, can they please raise their hand?
Mashodi in favor, Chair, thank you.
So Chair, those members who have voted in favour of clause 10 is Honourable Mashodi, Honourable Moimang, Honourable Dango, yourself, Honourable Tutuvo. Those members who have voted against clause 10 is Honourable Bashop, Honourable Prataseth, and no abstentions.
So much. Clause 11. Can you come in on this one before we vote, Ms. Isaac? Clause 11. Isn't it the one that we dealt with earlier?
No, Chairperson, that was, to my recollection, it wasn't.
So this one is not the one that we dealt with?
Not the 42A, this is 42A, big A.
Oh, okay, all right. Okay, Can we then vote those in favor? Can they vote in favor? Or raise their hands?
Mosodi in favor, Chair. Thank you.
So, Chair, those members who have voted in favor of Clause 11 is Honourable Mashodi, Honourable Moimang, yourself, Honourable Duduvu, Honourable Dango. Those members who have voted against is Honourable Bashoff and Honourable Brautiseth, and no abstentions.
Okay. This one was it was in the submission, not in the bill. So the one who was confused on the section 42, because it was in the submissions and the response. So we won't find it in the bill itself. Okay, we're now going to clause 12. Those voting in favor of clause 12, please raise your hand.
Mosodi in favor, Chair. Thank you.
So, Chair, those members who have voted in favor of clause 12 is yourself, Honourable Moimang, Honourable Duduvu, Honourable Mashodi, Honourable Dango, and Honourable Moimang. Those members who have voted against clause 12 is Honourable Bashoff and Honourable Brautiseth, and no abstentions.
Thank you very much. Can we please lower our hands? Please remind me, Ms. Mati, to ask members to lower their hands before we go to the next round. I might forget. Can you please lower your hand? We have not yet asked the question.
Okay, no problem.
Yeah, the question now is those in favor of clause 13, can they please raise their hands?
Mosodi in favor, Honourable Chairperson. Thank you.
Okay.
So, Chair, those members who have voted in favor of clause 13 is Honourable Duduvu, Honourable Dango, Honourable Moimang, yourself, and Honourable Mashodi. Those members who have voted against clause 13 is Honourable Bashoff and Honourable Brautiseth, and no abstentions.
Thank you very much. Can we lower our hands, honourable members? Okay, we're now going to clause 14. That deals with the Schedule 4 of the Principal Act. Those in favor of clause 14, can you please raise your hands?
Thank you, Chair. Honourable Mosodi in favor. Thank you.
Thank you so much.
So, Chair, those members who have voted in favor of clause 14 is Honourable Dango, Honourable Duduvu, yourself, Honourable Mashodi, and Honourable Moimang. Those members who have voted against clause 14 is Honourable Bashoff and Honourable Brautiseth, and there are no abstentions.
Thank you very much. Can we please lower our hands? Thank you so much. And we go to clause 15. Those in favor of clause 15, can you please raise your hand?
Honourable Mosodi in favor. Thank you, Honourable Chairperson.
Thank you so much.
So, Chair, those members who have voted in favor is Honourable Mashodi, Honourable Dango, Honourable Duduvu, Honourable Moimang, and Honourable Mashodi, I think I did, and yourself. And then those members who have voted against is Honourable Bashoff and Honourable Brautiseth, and no abstentions.
Thank you very much. The last clause is clause 16. Oh, sorry, let's first lower our hands. Sorry. Can we lower our hands before I ask the question? Okay. Those in favor of clause 16, please raise your hand.
Honourable Mosodi in favor. Honourable Chairperson. Thank you.
Thank you so much.
So, Chair,
That
those
was...
members...
Oh, okay, sorry, the result.
Yes, Chair. So those members who have voted in favor of clause 16 is Honourable Mashodi, Honourable Dango, yourself, Honourable Moimang, and Honourable Duduvu. Those members who have voted against is Honourable Bashoff and Honourable Brautiseth, and there are no abstentions.
Thank you so much. Can we please lower our hand? Honourable Moimang, can you please lower your hand? Okay, in any case, that was the last day. Can we just check from the legal advisor if any comments? If there are any comments?
No, Chairperson, there's no comments.
No comment. Mr. Makabeli? Yeah, you can go ahead, Mr. Makabeli. You can unmute yourself, please.
Sorry, Chair.
Okay.
I don't know if you'll do this with the report of the committee to just put the whole bill before the committee, Chair.
Okay. That's what I was checking with even the previous one, when I was asking for the way forward. I was expecting that you were there because
Yes, Chair.
close by close.
It can still be done with the report of the committee, Chair.
In the report of the committee.
Together with the report of the committee, yes, Chair.
Oh, okay. Okay, let's leave it at that then, so that it's a part of that, because so that we are consistent even with the previous one, which is a COID. Any other comments? No comments. Anybody else want to make a comment? Numbers, department. Office of the Chief State Law Advisor. Any comments?
No comment, Chair. Thanks.
No comment. Okay. Now, let me then take this opportunity to thank honorable members for your attendance at the meeting. Let me thank the staff of the committee and staff of Parliament, the Department of Employment and Labor, the Compensation Fund, the Office of the Chief State Law Advisor, and other staff members of Parliament, PMG as well, and everybody else who was in the meeting. Thank you very much for attendance and your participation. As we indicated that we will now compile a report that will be tabled in the meeting of the 22nd, which will be on Tuesday next week, to either adopt or reject the report next week. Thank you very much, honorable members. The meeting is adjourned. Thank you very much, and good night, everybody.
Thank you, Chair.
Thank you so much.
Thank you, Chair. Night.
Good night, Chairperson.
Thank you so much. Good night.